We hear you.
Now you can hear me. Okay, that's great. Ladies and gentlemen, we're a little bit under a time crunch, so I want to start. And the first person is our Director, Research and Innovation, Professor Mitzi Wiese, who will do the official welcoming. Mitzi?
Okay, good morning, everyone. Hearty welcome to the Hybrid Maintenance Law Colloquium, hosted here at the Northwest University Faculty of Law. On behalf of the Executive Dean of the faculty and myself, I'd like to take a moment to express our gratitude for your presence here today, both in person and online. Your participation in this colloquium is greatly appreciated, and your contributions will undoubtedly enrich our discussions. I would like to provide a brief overview of the research focus area and strategy of the Faculty of Law. We have a research unit themed Law, Justice and Sustainability. There are a number of research projects or then sub-themes in our research unit. These are justice in practice, vulnerable societies, environmental change, and finance and innovation. We also proudly host the NRF Chair in Cities Law and Environmental Sustainability. The theme of today's colloquium, Maintenance Law, is relevant to justice in practice and vulnerable societies sub-themes. We are really thrilled to have such a diverse and distinguished group of individuals gathered here to explore and exchange ideas on maintenance law. Our speakers include academics from higher education institutions, judges, and Department of Justice and Constitutional Development experts, legal practitioners, to name but a few. We want to acknowledge everyone for being part of our 2023 colloquium, and then also give a special word of welcome to our keynote speakers, Professor Leentjie de Jong, project leader of the South African Law Review Commission, advisory committee on the project on the review of the Maintenance Act. Professor de Jong will provide valuable insights into the Maintenance Amendment Bill 2023. We are also very pleased to welcome Mr. Eugene Opperman, who is a specialist maintenance attorney and mediator. Mr. Opperman will address us on mediation, on maintenance matters as alternative dispute resolution options and the practicalities and navigation thereof, with specific reference to relevant provisions of the proposed amendments to the Maintenance Act. I would also like to acknowledge Ms. Felicity Ann Guest, the founder of Child Maintenance Difficulties in South Africa. Ms. Guest, you are an inspiration with your tenacity to make a difference in matters of child maintenance and financial abuse issues in South Africa. Ms. Guest will also share her expertise in her presentation titled What Protection is Afforded to the Primary Parent in Maintenance Process. During this colloquium, we will be privileged to hear from esteemed speakers, engage in interactive discussions, and network with peers who share their passion for maintenance law. From the faculty side, I also want to express our gratitude and congratulate Professor Marita for this excellent initiative, attracting scholars and experts from various fields and industries. Marita, your passion for the law is enlightening. Thank you also for all of your hard work to putting this colloquium together. And then to Ms. Red Fender, thank you very much for all of your hard work as well to make this colloquium successful. So this colloquium is designed to be an interactive and engaging experience. You are encouraged to ask questions, share your insights, and actively participate in the discussions. It is also a great opportunity to network with fellow attendees. You never know where those connections might lead. It is now my pleasure to officially open the Maintenance Law Colloquium 2023. Welcome to each and everyone.
Thank you very much, Mitzi. Oh, you are excused. Oops. Ladies and gentlemen, before we start, I just want to say a few words about the coming together of the conference. I've been really inspired with what Felicity and Eugene is doing for maintenance. And we've been talking about having a conference for about 3 years now. And each time something happens, if COVID or lack of money or this or that, the other, we decided this year we have to do it. And I am so pleased that I could facilitate having all the people here that's here. And I think it says a lot about the necessity for a colloquium like this. And we hope that this would be an annual gathering, or every 18 months at least. And then also for those who are interested in, so that we can get more writings on maintenance issues. We will have this special Potchefstroom Electronic Law Journal version next year for family matters, but also including maintenance matters. So you all, as you heard, are very welcome. And I'm very glad to see so many of you online and in person. Not only will it be available online on our platforms, but Eugene very kindly is also taping it. You can see he's a much more electronically savvy person than the rest of us on his platforms, because what we want to do is we want to spread the knowledge as far and wide as possible, so that more people know exactly what to do and how to do it, and so on and so forth. So our first speaker is Felicity Ann Guest. As you heard, she was specially welcomed. Now, I think if anybody has done something for maintenance awareness in South Africa, it is Felicity. Apart from being the founder for Maintenance Difficulties, she's also the recipient of a Human Rights Award in 2018, and she's one of the Ackerman's Faces of Change, specifically in 2021. She will tell you about her experience and so on, and we're very happy to start. And when we set the program up, we thought maybe, for us boring academics who tend to forget the real hardship, to start with 2 presentations, just setting the gloomy stage, of which Felicity is one. So, Felicity, you are up. You have your 20 minutes. I just want to quickly get your PowerPoint. Meshach. How do I get that thing there?
You can just click here.
Okay.
And then you choose which one is it.
No. That's not helpful. No. Is hy hier op? Kom help, papa. No, net gesit het, ja. Just hold on a second, ladies and gentlemen. All people like me are electronically challenged, and I need all the help I can get, as you can see.
Hy's nog op die memory stick.
Sy nog. Yeah,
Is dit
okay,
nog
we
nie
found
op?
it.
Is dit hierdie ene? Kom ons kyk gou. Daai ene.
There we go. Felicity, we found it. There we go.
That's right. Daai ene moet ons net. So.
Okay, Felicity, your 20 minutes starts now. You can do your slide yourself. There we go. This one. Yeah. Yeah.
Good morning, everybody. Thank you, Northwest University, for hosting this. It is much needed. Great to see all of you here, and welcome to everybody online. This is my heart. This is my passion. I eat, sleep, and breathe this. So I would like to
It's not working. Take the keyboard and
Technical
just,
challenges.
There we go.
So the Maintenance Act is not gendered, but we cannot deny that the impacts are very gendered. Maintenance can not only change the lives of children and mothers, it can change whole communities, corrects many other inequalities in South Africa. We have the legislation, the systems and the structures, they're all in place. So what is lacking is the what's and the whys. And I'd like to start, if you have a look at the UN Sustainable Development Goals, all of the ones without a cross is what will be impacted if mothers get child support for their children. That is how important getting child support is to address the inequalities in South Africa. If we have a look at our population, we have a population of 62 million. Females make up 52% of that. The unemployment stats, 35.7% are women. And we know that it's a lot more than that. 40% of divorced or separated women were more likely than other women to have experienced physical or sexual violence that's ever experienced. This is not even taking into account the covert forms of domestic violence. So what are the drivers of where we are with maintenance? And maintenance is an inequality issue. We have a look at the historic reasons. South Africa has a violent past. It's unequal, and there's a lot of anger in both genders. We're still a very patriarchal society. There's a huge power imbalance, the very typical gender roles and relations, the economic inequality. And this is a very important aspect. Men have economic privilege, and women have the unpaid care work. Domestic violence, it doesn't discriminate, but it is very gendered. Poverty, one of the most unequal countries in the world. And the effects of domestic violence needs to be understood by social workers, the legal profession, psychosocial, and the justice system. Because unless, how do we go back? Unless we change all of that, nothing is going to change in South Africa.
There you go. Is that the one you want?
If we just, is that the one? Yes, thank you. So we can't, if we have a look at all of those factors, we cannot deny that women are incredibly vulnerable in South Africa. So what are the causes of the vulnerability? Motherhood, gender-based violence, economic inequality, and poverty, probably four of the most important ones. So if we look at the hierarchy of women, the woman who is married without children sits at the top of the hierarchy. The unmarried woman who is childless is just below her. The married woman with children, her social value starts being diminished. And the woman who is most affected is...
Sorry. There you go, sorry.
Is the unmarried mother who has children. She sits at the bottom of the hierarchy. She experiences the worst social standing or value. She is at the bottom. Her value is almost zero in society, but we're going to focus on this in the justice system. So here are the stats of women who are divorced or separated, who are more than likely to experience gender-based violence, domestic violence. We cannot ignore that figure. We are not talking about a small percentage. And the one thing I want you to take notice of is the huge percentages that we talk about. So this is, as I said, excluding the covert, the silent, invisible forms of domestic violence. And then the stats show us further that the wealthier you are, the less likely you are to experience domestic violence, or your ability to escape a domestic violence relationship and survive thereafter. So the poverty, and in relation to South Africa, who are those women? The majority. These are single-headed households. 47.7% for rural, 39.6% for urban. And if you look at the provinces, Eastern Cape, the responsibility that single mothers carry is enormous. And I cannot emphasize that enough. And then I want us to just consider what is violence. So traditionally, when somebody says violence, they think about the physical violence because it's visible. If I have a black eye, I do not have to say a word. But if I'm experiencing economic abuse, not a single person will know unless I tell them. So violence can be contact or non-contact behavior, which causes physical and psychological harm. I've excluded others because they can all fit under psychological harm. So the overt ones, the black eye, is tangible, and that goes, unfortunately, for sexual abuse as well. The covert, less tangible ones are verbal, emotional, mental, economic, because they are invisible and they're silent, and they're so difficult to prove. I made submissions to the GBVSNSP at the last minute, and I'm proud that as a result of my submissions, focusing under economic abuse and the harm it causes, that in the definition of gender-based violence, maintenance has been included as a tool used to cause harm. Economic abuse is included in the Domestic Violence Act. Interim maintenance can be ordered at a bail hearing, as well as emergency monetary relief can be sought through the Domestic Violence Act, as well as protection under the economic abuse provision. And this is all money. We cannot ignore it. Maintenance is money, but we need to understand the deeper issues about it. So intimate violence is a public mental health issue, overwhelmingly experienced by women who bear the burden of these experiences. A root cause of this, they say, is gender inequality, something that manifests itself at all levels of society. This is research that was done by Lancet, and there were many academics that contributed to it. Worldwide, the stats are 27%. South Africa's stats are 50%. IPV is endemic in South Africa, and it's entrenched because of the many social problems. And we've normalized those problems. We ignore them. No integrated, cohesive response from all sectors. We have this siloed approach. And the impacts of IPV are not just physical, but psychological distress. I have not received maintenance for more than 5 years. I lodged my arrear maintenance application, and we have appeared in court at least 20 times, and still I have not received my maintenance. I've sold my car, moved back into my parents' house. I've been blacklisted while he lives the high life. He has a new car, new partner. He is thriving while I'm drowning. That is the story of the majority of women who are trying to get financial support for their children. It speaks to the heart of gender inequality in this country. Just very quickly, so we need to understand the intersection with domestic violence, and I'm not going to go too much into this. This is available everywhere, and our slides will be available. So in relationship, this is what the domestic violence wheel looks like. And if we just look on the right-hand side, intimidation, emotional, coercive, controlling, male privilege, physical, sexual, economic abuse. Children are used as tools, minimizing, denying the abuse, and blaming, and the isolation of a victim. Very typical in relationship abuse. But it doesn't stop when the relationship ends. It just changes shape and form. But the abuse will continue. And what is the most powerful tool post-relationship? Can be done remotely? Money. And in order to understand this, I believe that people really need to understand coercive control behavior. It's been included in our Domestic Violence Act. If we look at coercive controlling behavior and we understand it, then we can recognize the pattern of behavior. Then we just have to look for the tool. Once we find, it could be sex, it could be children, it could be money. Find the tool. All of abusive behavior follows a pattern. Unfortunately, I believe that ours should have been coercive controlling behavior, but in our amendments, they've got coercive behavior and controlling behavior. But it is a pattern of behavior that causes harm. And the words that are used in the sector is sabotage, held hostage. What image does that create for you? Not paying child support keeps a mother kept as hostage to who? The father of the children, who has a legal obligation to support them. So, irrespective of how the children come to be, divorced, planned, unplanned, single, long relationship, no relationship, a casual relationship, rape, and adopted. We all end up in the marsh pit. None of us are excluded. So when people go, get married, it's because people are having to learn how to marry, or women are not taking responsibility and using contraceptives. The blame and everything is shifted onto the women, but we're not holding men accountable. And we see that in the maintenance court, but it does not discriminate. We all end up in that dirty, mucky pit. And the problem is, the child does not have locus standi. So who represents the child in court? In the majority, women. And guess what? They are glued to their abuser because of their children. If a woman does not have children, she can pack her bag, she can leave the country, never to see the perpetrator again. But if you have children, you do not escape them. And it becomes the covert, silent, invisible forms of abuse that are the most harmful. And that's why nobody sees it. I did a poll on my group in 2019, and I've done it several times since then. Look how many mothers are not getting a single cent. 54%. Old Mutual did research with a cohort baseline of a minimum of earning 8,000 Rand a month. Their stats were 47% get not a cent, with a baseline of 8,000 Rand a month. The majority of women fall underneath that baseline. So just the figures are not, they're probably worse than that. I say that they're probably 65%. And that's probably still conservative. And you can see, if we look at the food baseline poverty, which abject poverty, which is at 750 Rand a month, that's enough nutritional value to get up and go to the toilet and breathe, not even run, not even catch a bus, not even go to school. What is our social grant? So if women are not getting a cent, what is the impact on our children? Mothers are going without food, so they can feed their children. Just very quickly, so how does financial abuse present itself post-relationship? The first thing that happens is money is cut off immediately. I'm leaving you. I've had enough. Our marriage is broken down. Whether there's physical abuse or any other form of domestic violence, our marriage is over. I'm leaving. This is my house. You get out. That's immediate vulnerability. When she goes out, money is cut off. Whether it's a joint bank account, even if she has her own bank account, who's supporting the children? It's supposed to be a he's happily paying school fees and buying food. The moment you leave the relationship to punish you, all money is cut off. And then you have to fight for it. You have to fight for Rule 58, through a Rule 43, and then a maintenance court, even if you've got a court order. It's a constant fight. But if we look at the impacts, they are dire. And one of the reasons is because if there's any kind of physical abuse, you go to the police station, you get a J88, you go off, and it becomes evident. Anybody who looks at a J88 at a very quick glance can see exactly where the harm is caused. Femicide, we know, one of the highest rates in the world. There's an autopsy report. We get to know evidence. Economic and financial abuse, how do we report it? There is no simple way of evidencing the harm that victims experience. It's a problem. Because I'm trying to explain your harm. You don't have a narrative, you don't understand the legislation. All you know is that you're feeling abused. How do you articulate that for somebody to understand? Oh, baby mama drama. Typical women, so emotional. It's all about money. Shut off and not heard. Women stop talking because they're not heard. So economic abuse is about the behavior, and financial abuse is about the money. Just very quickly, the complaints, very common. Bias towards the fathers, no documents provided. They're unemployed and they get a free ride. Women carry the financial burden. It takes so long from the beginning to the end. Forced to sit next to my abuser in maintenance court. A huge problem. Who knows? Impunity, court staff attitude. And I'm going to wrap up now, but if anybody wants to see the rest of my slides, they're available. Is why are we not doing risk assessments? When applicants go to the maintenance court, why is there not a risk assessment? Why is a vulnerability not established? Because that would show, I've been evicted. Okay, the problem here, when you act, there's no time to postpone. People who see this constant pattern with every single application will start seeing the impacts. And I believe that the behavior will automatically start changing. This has got to become victim-centered and victim-focused. We cannot force victims, and anybody having to go to court to beg for money is a victim of economic and financial abuse, which falls under the Domestic Violence Act. It is victim-centered. It needs to be victim-centered and victim-focused because we do not feel heard. We do not feel seen. And our children are suffering. Thank you. That wraps it up.
Listening to Felicity is always one of those double-edged swords. I really appreciate the enthusiasm. What she says really depresses me. But Felicity, thank you very much. We will have an opportunity for questions later. Again, your work that you do is fantastic, and we really appreciate your passion. And in a way, I've got to thank your ex-husband for what he's doing for the bigger picture. I have a few other things I'd like to say to you too, but that's beside the point. Our next speaker is Dr. Carmel Jacobs. So also here from the Western Cape. I have a nice slide on her, but I know that if I go away now, I'm going to come back. So here you go.
Thank you so much. Am I loading the presentation myself?
Yeah, okay. We're there. Okay, and you can just, it is shared, just go to slide. There we go.
Good day, everyone, and thank you for this opportunity. I am in the unfortunate position of being both a boring academic, like the rest of you, and
Speak for yourself.
no, you introduced us as boring academics, so I'm both in that category, and I'm unfortunate to be in Felicity's shoes as well. So, yes, this journey for me is embarrassingly personal, because how do you have 3 law degrees, but you are having personal experience with getting maintenance for your children? It's not supposed to happen. I mean, you know, there's this perception anyway. So the title of my presentation is something to talk about is South Africa's child maintenance system, failing our children and impoverishing women. So all of you should know this, a child's right to maintenance. It's based on a child's reasonable needs. So it's a pro rata calculation, not 50-50, like so many people believe, because we all contributed 50-50 to the child's conception. The perception is therefore that it is also 50-50 contribution based on each parent's financial needs, financial income and availability or ability to provide. And this includes housing, food, clothing, medical care, education, and other necessary expenses. What are the requirements for a maintenance claim? It's the existence of a duty of support. The person needing maintenance cannot maintain themselves, and the respondent can afford the maintenance claimed. So what's my story? So I was separated in November 2020. My ex-husband promised our housekeeper, don't worry, your job is secure. I want to raise your children. I want you to raise my children until they are 18. I've since heard that this is called the honeymoon phase, where they make promises, okay? He made these promises to her unsolicited. I wasn't even part of the conversation. Nothing will change. Then when it came to me in January 2021, he made the maintenance promise. I asked him for a contribution pending the finalization of the divorce. I said, let's mediate this. You know, we don't have to be enemies. Let's resolve this in an amicable manner as quickly and as painlessly as possible. The maintenance that I requested was less than 50% of what I actually needed, but I wasn't trying to be greedy because I'm like, I have a job, I work. He's like, no, it's fine. I'll help you transition. If you need any financial support to help you cover things, I will provide that. You keep the house. It's important for the girls to have stability. Yes. And so he paid from Jan to August 2021. And then in August, I got an email where he is refusing to pay, just decided unilaterally. And I said, but what about the agreement via email? No, I am not bound by that. And so I referred him back to the email, and so he paid. And then the second email, the 21st of September, I'm just letting you know, I won't be paying maintenance at the end of this month. You can speak to my lawyer. And so in October, I received no maintenance. And tomorrow, 2 years ago, I had my first visit to the maintenance court. Okay. Then in November, he unilaterally decided to contribute $3,000 for both children. So that's 1,500. So he went from 14,800 to 3,000. And when he issued summons, he offered 3,000 per child. So what he now was paying was half of what he offered in the summons. But you can imagine it was so much less than what he initially agreed to. from June 2022 until July, after I got an interim order, he paid 10,000, but in terms of his interpretation, it included school fees, but the order said nothing about school fees. And our divorce was finalized on the 12th of July. Since the 1st of August, I now get 12,000 in maintenance, which is a lot, I know, as the cash component, and we agreed to a 50-50 split. Now, I should tell you he's already defaulting. He's refusing to contribute to fuel because apparently my children get there by water. He refuses to cover the pet's expenses that he brought 5 years ago. And the housekeeper's bonus for the past 2 years was outstanding, but he finally paid it, the 2022 bonus recently. What is my legal process? I first had to go to the maintenance court, but what happened when I got there, he lawyered up, refused to produce documents. I spent all that money preparing bundles, and then his attorney served me with a notice saying, well, you know what, this is already part of the divorce, so your attempts to bring this to the maintenance court are futile. And the poor maintenance officer was intimidated, and she says, no, let the magistrate decide this. So there my maintenance matter hung. So there wasn't even a question of best interests. Then I brought an application for Rule 58, cost me 70,000, didn't have. And this was already 2 years into litigation. Again, I had to settle, so I took the 10 because it was better than the 3 I was getting, thinking the divorce was going to be finalized soon. And again, the magistrate didn't ask best interest. It was literally an attempt to just settle this matter, one less matter on the docket so we can move on. Then divorce trial, again, pressure to settle, no question of the children's best interest. And then there's this assumption that both parents will act in the children's best interest. There's this assumption. You both have lawyers, so it must mean that you are reasonable people. Nobody asked. I mean, that magistrate wasn't interested in any of that, unfortunately. And so what conclusion have I reached from my terrible experience is that the maintenance system has failed my children. Yes, my kids are getting more than what you identified. But here's the sad reality. As part of this entire divorce process, we had to go for mediation, which cost me 20,000. It also failed. Why? Because 3 days after we reached an agreement, before it could be typed up, he reneged. And the mediator calculated that his cash contribution is 20,000 per month. He agreed in mediation to pay 15. That was what I was willing to settle on. But somehow in this divorce process, I now come out with 12. So I'm effectively losing 8,000 a month. But I just could not keep fighting because I didn't have money for legal costs anymore. So sorry, this just gets me all emotional. So the question of what my children are entitled to was overlooked, completely overlooked. The maintenance court or the maintenance officer wasn't given an opportunity because she was blocked. The magistrate wasn't interested. The only person who cared was the mediator, and that failed. According to the calculation that she made, he is liable for 62% of my children's expenses. And I am liable for 38%. So that tells you how much he earns compared to how much I earn. Sorry. When he moved out, he took the car. So I had to purchase a new car. I have to pay a bond because my children need stability. At times I've had to work 2 jobs and he can just refuse. So what are the losses that women suffer? Lost maintenance. For people in general, sorry, you weren't supposed to need tissues for my presentation. Time spent at court, leave from work, lost income, repeat visits. When you start recognizing people at the local checkers from maintenance court, you know you're in trouble. Months and possibly years without any or adequate maintenance, and then there's no reimbursement while you're waiting for the maintenance matter to be finalized. Gender-specific impoverishment, what are women specifically? Because the reality is women are still predominantly the primary caregivers. Let's be real. They're not allowed Section 11(1) subsistence and travel allowance. They need to make those stupid photocopy bundles. I mean, you can't make that at work. You have to go. I mean, you can't use the university's resources. If I think about what those 3 lever arch files cost me, and then what happened to it? It's in a cupboard somewhere because of that blocked attempt. In the criminal court, if the accused is undefendant, they get particulars for free. So there seems to be a benefit to the men that women don't get. And when mothers apply for attachment of assets, the sheriff requires a security of 5,000. Who has 5,000 lying around? Not me. And if you want to appeal, there's an 1,000 Rand appeal fee. Who's got that kind of money? My daughter needed braces in the past month. My younger twin braces cost 10,000. And my daughter, the elder, had surgery 2 weeks ago, and there was a co-payment of 10,000 because I had to cancel the gap cover because my maintenance, I was just not getting enough. So I just have to keep on forking out and forking out. And so where does that leave me? What are the specific losses? When my ex-husband moved out, he said to me, give me the savings, you have the house. The savings was 100,000. He promised to get an apartment which was suitable accommodation for the children. What did he do? He moved in with his mother. That money's gone. And my children had to share a bedroom with him for the past 3 years. That isn't how they grew up. They've always had their own room. And now they're teenagers having to share with their father. You know, where's the privacy? So now when they come home to me, they go to their rooms and they close their door because they haven't had that the entire weekend. Then between January and September 2021, I got insufficient maintenance because what he was giving was actually less than he was supposed to. That was about 45,000. And then between October 2021 and May 2022, I lost maintenance in the amount of 136,000. June 2022 to July 2023, lost maintenance 140,000. This was based on the mediator's calculations. And then since the divorce has been finalized, my children are losing 8,000 every month. So since the divorce, the separation, my children have lost 445,000 in maintenance. What about my losses? Legal fees for this divorce, mediation, Rule 58, 184,000. Accrual, yes, he has no assets. So the responsible parent or the responsible party still has to suffer and I have to pay him out. 485,000. My debt currently 150,000. So So the total losses that I've suffered in the past 3 years is 819,000. My children and I have lost 1.2 million, 64,000, you can see, in 3 years. And every month that amount increases by 8,000. He earns in US dollars, tax-free. He's out of the country half the year. So who does the parenting? Who bears the losses? It's not him. Like Felicity, he gets to move on. He's got a car parked in a garage that he pays 6,000 Rand every month, that is parked half the year. That's the reality, people. He recently moved in with a woman, and my eldest child is refusing to go. That's my reality. He doesn't pay for the extra. She needed a costume for tomorrow, for school, 100 Rand contribution. He just said he had no money. Do I have the option of saying I have no money? So what are my regrets? Sacrificing my children's interests, settling for 2/5 of what they are legally entitled to, but I just didn't have the energy to fight anymore. I wish that the cost of litigation was not as expensive. Yes, I could have defended myself, but the mental onslaught that a battle like this puts you under. I mean, where do you end up? So many women give up because of the battle fatigue. I wish there was a better system in place. Greater protection for the primary caregiver, that we didn't have to go through 5 years without maintenance. Protection against financial abuse, because as Felicity says, it's not visible. Even if I talk about it, people don't believe me because you're living in the same house, you're driving this car, but people don't understand what it costs you. Should the child suffer because one parent is holding out, I will rather take on 2 jobs so that they don't feel the brunt of it. They don't know half of what I'm dealing with because they're children and they shouldn't have to. I wish I could have avoided the battle fatigue, but by the time the divorce rolled around, I was like, the trial dates, I'm like, whatever. I wish I got payment of that area maintenance, but who has the energy to fight for that? And I wish there was greater liability for the defaulting parent without the need for further litigation, because I just don't have the energy. What are the current problems? There's a lack of an appropriate legal framework, inadequately trained staff. Maybe they're just overwhelmed and desensitized with all of the claims that they have to deal with. The underlying problem is really a lack of accountability on the part of the defaulting parent, because they have a choice. They can choose not to pay and walk away, but the primary caregiver has no choice. We're stuck. We're held hostage to our situation. Both of my parents are deceased. I don't have the option of moving in with parents. So do we accept the continued lack of accountability? Do we just accept that one parent will always pay or carry this burden alone? Do we accept that children get less than they are entitled to? And do we accept that women will forever be impoverished under the current system? So what are the solutions? How do we force accountability? Well, it needs to be up to government, because parents, primary caregivers just don't have it in them anymore. So what is my solution? SARS. That is my solution. If SARS can tell me how much tax I need to pay, why can't they tell the other parent, this is what you must pay? New Zealand has a system like that. Child maintenance is overseen by Inland Revenue. And so it's not a novel idea. This has been suggested years ago, but at the time SARS was in shambles. But I think you all agree things have improved tremendously in the past few years. Can't a woman just submit a claim, say, I have 2 minor children? They work out what the child's basic needs are. The father then has to say, okay, this is what they can tell what his income is. This way, there's a more objective standard applied. There's the element of intimidation of maintenance officers is eliminated. There's less time visiting maintenance officers, less financial strain on the primary caregiver, less emotional strain, a shorter implementation period. It forces accountability on defaulting parents. There's still room for appeals and review because you all know with SARS you can appeal if you're not happy with the outcome. And maybe this then goes to our maintenance courts and maintenance officers if needed. Now, I know everybody is not in the unfortunate situation that I am, where I have an ex-husband who is withholding for no good reason. He doesn't have a reason. He doesn't own property. But yet he just refuses. And I feel like that for me is an insurmountable hurdle, because how do I deal with those? It's just a blockage. Mediation failed me. So for me, I know that isn't even a solution. Because who am I mediating with? It's not someone who's willing to meet me halfway. It's someone who's just trying to avoid their responsibility. Thank you. I'm sorry for the tears.
Thank you very, very much. I think if ever there were 2 good speakers to have to set the early stage in part 1, I think this is it. And Carmel, I'm sorry, just as I am for Felicity and for you, I don't think any woman should go through this. And I like your suggestion. Okay, ladies and gentlemen, what we're going to do now is we're going to now move over to our 2 keynote speakers. Let me just get to the desktop. And the first person is Leentjie, Professor de Jong. There we go, there we go. Leentjie is old academic. I will never call Leentjie boring. She's no longer an academic. She's now a full-time mediator. She is really one of those people in the South African family law and maintenance that has made a huge impact with her research. And apart from the papers and so on, she's also on the advisory committee of the Law Reform Commission and project leader with regard to the review of the Maintenance Act. So Leentjie, I'm going to hand over to you. I just want to make sure that I can get you to present. Okay. Okay, I'll stop sharing now. You can reply. Somebody more by the looks of it.
Yes,
It will only be Bridget
bothering.
that's
Maybe
doing
we can just
exercise.
put his photo on. We can just put his camera off. Anyway.
What camera? Camera off. There we go.
Can you, okay, there's my slides. Are they small? Can you see them?
We can see them, but can you make them bigger maybe?
Yes, I will do that immediately. Can you see them now?
Well, they're still the same size. Is that good enough for everybody can see?
No,
Okay,
are they
Leentjie?
bigger now?
Yeah, yeah, a little bit. Okay, the floor is yours. Your
Maybe
time
if you can
starts now.
just open the screen on the widest setting, the biggest screen setting.
Oh,
You just make it the full screen. I can now not see anybody, but you can see the PowerPoint presentation.
we can see the PowerPoint. Okay, there we go.
Okay.
The floor is yours.
Okay. Thank you. I can't see anybody, so if something goes wrong, please just stop me. Okay. As we have limited time, I'll address only the most important changes to the existing chapters of the Maintenance Act 99 of 1998, as proposed by the Law Reform Commission's Maintenance Amendment Bill, and it's of 2022, not 2023. But anyway, as far as Chapter 1 of the Maintenance Act entitled Interpretation and Application of Act is concerned, a few new definitions are to be inserted into Section 1, including a definition of applicant or complainant that is intended to ensure that any person, are they going forward? Oh, that any person who has an interest in the well-being of a maintenance beneficiary will have locus standi to institute a claim on behalf of such beneficiary, including the parent or grandparent with whom an adult but dependent child lives. In the meantime, this principle has been confirmed by the SCA for High Court matters in Z versus Z, and in the Western Cape High Court case DWT versus MT, specifically for maintenance court matters. Through this amendment, the Maintenance Act will be aligned to case law, and the message is clear. Adult-dependent children should be removed from the conflict between their parents in maintenance matters, unless they themselves elect to assert their right to the duty of support. As regards Chapter 2 of the Act, which deals with maintenance courts and court officers, it appears that there's a lot of dissatisfaction among court officials about the difference between the two categories of maintenance officers for which Section 4 of the Act currently provides, namely, public prosecutors who are deemed to be maintenance officers and employed by the National Prosecuting Authority, and maintenance officers appointed by the Minister and employed by the Department of Justice and Constitutional Development. The question is whether we should only have maintenance officers who deal with maintenance inquiries, or whether we should do away with maintenance officers and only have prosecutors who deal with maintenance inquiries. Although some people who made comments on the discussion paper feel that there should only be maintenance officers, as prosecutors who mainly conduct prosecutions in criminal matters aren't trained to deal with maintenance matters between family members, many others indicated that the current expertise in dealing with maintenance matters lies with the NPA, and that all maintenance constraints currently experienced by the government, the Commission decided to stick to the status quo, but to address some of the concerns with each category, inter alia, by making provision for proper training for prosecutors and for maintenance officers to report to the senior public prosecutor assigned to deal with maintenance matters, instead of to a court manager who might not even have a law degree. Various important changes are proposed to Chapter 3 of the Act, which deals with maintenance inquiries, namely the introduction of mediation and the provision for interim maintenance orders at the inquiry stage. It's important to note that the alternative of mediation is generally regarded as a better choice than court proceedings, because in the mediation process, parties can negotiate solutions that are suited to their own circumstances, and they're assisted in recognizing their responsibilities towards their children and other dependents. It's also important to note that Project 100B, in terms of which the Maintenance Act is being reviewed, should be seen in conjunction with other ongoing projects of the Commission, such as Project 100D, under the auspices of which the Family Dispute Resolution Bill of 2020 was published. Although the Family Dispute Resolution Bill makes provision for mandatory mediation in all family law disputes, which naturally include maintenance disputes, it's foreseen that in terms of the exceptions clause in the Family Dispute Resolution Bill, most maintenance matters will be exempted from mandatory mediation.
Leentjie, I'm going to stop you there. I think there's a problem with the sharing.
Yes. Okay. I'll quickly stop sharing. Is it still on the same slide?
Yeah.
Oh no. Okay. Sure. It never shared.
Try again. Try again from scratch.
PowerPoint live. Okay.
There we go. I'm seeing you. So just share again.
Haven't you seen any of my slides?
Just the first one. That's why
I cannot believe it.
and they look like very nice slides.
Oh, they're so nice.
Leentjie,
Okay,
do me a
but we'll
favor.
carry on. I'm just going to go there quickly.
Do me a favor and also send all your slides to me so that we can
No, but it
upload
makes it
as well.
very interesting. Okay, let's just see if this helps. No, let's just see.
Share again from
Share.
scratch.
Let's go to PowerPoint Live, Notes. Okay, let's just see.
Don't see nux. Seeing your eyes frantically moving from space to space.
I'm in flight mode now. Okay, but let's see. I cannot understand. Okay, there we go. Can you see something now?
Yes, there we go. Okay, cool. Thanks.
Okay, I'm going to start with chapter 3 again, quickly. Okay. Various important changes are proposed to chapter 3, which deals with maintenance inquiries, namely the introduction of mediation and the provision of interim maintenance orders at the inquiry stage. Okay. It's important to note that the alternative of mediation is generally regarded as a better choice than court proceedings, because in the mediation process, parties can negotiate solutions that are suited to their own circumstances, and they're assisted in recognizing the responsibilities towards their children and other dependents. It's also important to note that Project 100B, in terms of which the Maintenance Act is being reviewed, should be seen in conjunction with other ongoing products of the Commission, such as Project 100D, under the auspices of which the Family Dispute Resolution Bill of 2020 was published. Although the Family Dispute Resolution Bill makes provision for mandatory mediation in all family law disputes, which naturally include maintenance disputes, it's foreseen that in terms of the exceptions clause in the Family Dispute Resolution Bill, most maintenance matters will be exempted from mandatory mediation. Complainants or applicants will almost invariably be allowed to approach the maintenance court directly on the grounds of economic abuse by family members, urgency, potential hardship, and or the best interests of the child. Therefore, to ensure that all parties, including children, benefit from the advantages of mediation in cases where maintenance complainants are allowed direct access to the maintenance court, mediation should be formally built into the maintenance court process through legislation. Although there's no provision for mediation in the Maintenance Act, it appears that some form of mediation does indeed take place. Firstly, at the stage when information and documentary proof are gathered by a maintenance officer, and secondly, at the informal meeting with the maintenance officer just before the formal inquiry in court. It appears that many maintenance complaints are resolved by maintenance officers at the investigation stage. It's therefore submitted that the mediation process, which is already in place, should be formalized, encouraged, and improved to ensure future successes. As such, the amendments make it obligatory for maintenance officers to provide mediation services to parties at the investigation stage after all relevant information and documentation have been supplied by the parties. However, parties who choose private mediation services are given the option of doing so at their own expense. As regards interim maintenance orders, the Commission takes cognizance of the fact that a maintenance matter should be regarded as an urgent matter in circumstances where, for instance, any delay could jeopardize the well-being of the maintenance recipient. Similar to situations in which the Domestic Violence Court is empowered to make interim awards for emergency monetary relief in terms of the Domestic Violence Act. As complainants are very rarely granted emergency monetary relief in the Domestic Violence Court, it's the Commission's opinion that the Maintenance Act should make provision for a similar process in the Maintenance Court. Extensive amendments to sections 6 and 10 are therefore proposed to enable the Maintenance Court to hear ex parte applications and make interim maintenance orders to provide immediate relief for applicants or complainants where possible. The amendments provide that once a maintenance matter has been lodged and proof of income of the person legally liable to maintain is available, the matter should be taken to court on the same day or at least at the earliest possible date, so that the court may make an interim maintenance order. Provision is also made for maintenance matters to be brought outside of court hours if circumstances warrant this. However, in circumstances where there's no order and proof of the financial circumstances of the person legally liable to maintain has not been supplied by the applicant, an interim maintenance order should not be issued, and the maintenance officer must investigate the application or complaint either in the prescribed manner or as provided for by the court. This brings us to the amendments to Chapter 4, Maintenance and Other Orders. Various amendments to Section 16 are proposed to empower a maintenance court to make a wider variety of orders. Provision is made for payment in kind, which in terms of the definitions clause can be made by way of supplying specified goods such as livestock or providing a service or services. When making an order for payment in kind, the court must also make an order in the alternative for payment of a sum of money equivalent to the estimated value of the order for payment in kind. As our courts, even the SCA, still have difficulty in distinguishing accurately between the circumstances under which a trust can be declared a sham or a simulation, and the circumstances under which the veneer or veil of a trust can be pierced, it was decided to include the following provisions in Section 16. The court may declare a so-called trust a sham or a simulation inter alia in the following circumstances: where the requirements for the establishment of a valid trust were not met, or where the appearance of their having been met was in reality a dissimulation, where the founder had no real intention to create a trust, or where the creation of a trust has no commercial substance, or makes no sense in the opinion of the court. Whenever a so-called trust is declared a sham or a simulation, there is no trust, and any assets and income of the so-called trust form part of the personal estate and income of the maintenance debtor who purports to be the founder or a trustee of the so-called trust. The court may further, where the existence of a valid trust is accepted, but there's justification for disregarding the ordinary consequences of the trust existence for a particular reason, disregard the separate legal personality of a trust, inter alia in the following circumstances. Where the core idea of the trust concept, namely the separation of ownership or control from enjoyment, has been debased or is being abused, where one or more trustees of a trust is treating the property of the trust as if it were their personal property and using the trust essentially as their alter ego, where there's failure by the trustees of a trust to adhere to the basic principles of trust administration, or where the court deems it just and equitable in the particular circumstances of a matter. Whenever a court decides to disregard the separate legal personality of a trust, certain or all property of the trust or the value thereof or the income of the trust may be taken into account as the property of or the income of a maintenance debtor who is the founder or a trustee of such a trust. Then a whole new chapter, chapter 4a, entitled Future Maintenance, is inserted into the Act. We have since decided to make a chapter 5a because it actually deals with execution, but for now, let me just discuss it where it was at the point when the discussion paper was published. Case law has for some time made provision for the issuing of future maintenance orders in the High Court and also in the Maintenance Court. To align the Maintenance Act with these cases and to make provision for a uniform approach to applications for future maintenance, the new chapter makes it clear when and how orders for future maintenance should be made and which institutions need to administer the money attached for future maintenance. In terms of the new section 25a, whenever any person legally liable to maintain another has not been bona fide or recalcitrant with regard to his or her maintenance obligations at any given time in the past, or where the future maintenance claim of a beneficiary is threatened by conduct amounting to reckless spending, whether or not the person legally liable to maintain has been recalcitrant or has not been bona fide with regard to his maintenance obligations, and if there are no further emoluments available to satisfy payments towards monthly maintenance, then the person to be maintained or the person in whose care the person to be maintained is, may apply for the attachment of a lump sum in the court within the area of jurisdiction where the person to be maintained or the person in whose care the person to be maintained is, resides, works, or does business. In terms of this section, any sum of money from any source whatsoever that is due to the person against whom the order was made and is payable in a lump sum or payable in installments over any period of time, including any pension, annuity, gratuity, payment from a living annuity, compassionate allowance, or other benefit, shall be liable for attachment to secure future maintenance in favor of a maintenance beneficiary. Similarly, any property previously held in the name of the person against whom an order for payment of maintenance has been made, but to which the rights thereto have, after the date on which the order was made, been transferred or abandoned by way of delivery, payment, release, compromise, or donation in terms of any contract and not for value, shall, in the absence of proof to the contrary, be deemed to belong to the person against whom the order for payment of maintenance has been made and be liable for attachment to secure future maintenance in favor of a maintenance beneficiary. When order is made against a fund and or the insurer administering benefit payments from a living annuity or other similar product held in the name of the person legally liable to maintain, the fund and or the insurer will be obliged to make payments to the maintenance applicant at the intervals and percentage rate determined by the maintenance court. Where the fund and or entity is not in a position to administer maintenance payments to the applicant, the fund and or entity shall transfer the amount for future maintenance into a beneficiary fund as defined in the Pension Funds Act, or, if such a fund is not available, to the Department of Justice to be administered in terms of the Justice Administered Fund Act. The amendments to Chapter 5, Civil Execution, firstly entail wider and more effective enforcement mechanisms. In addition to a warrant of execution against property, the attachment of emoluments, and the attachment of debts, a maintenance court is also empowered to utilize any other remedy it deems just and equitable in the circumstances of a case to encourage a maintenance defaulter to comply with his or her duty of support. The choice of a remedy is no longer limited, and the applicant will have the option to apply for more than one remedy in the alternative after obtaining the necessary assistance of the maintenance officer, who will be obliged to investigate the application upon request and to identify possible assets that would be susceptible for attachment. Provision is also made for applications for enforcement to be made ex parte and on an urgent basis. Where the maintenance defaulter, although in arrears with maintenance payments and pleading poverty, has, for example, transferred money or property to a third party for no value in return, an interim attachment order can be made, calling on all parties involved to show cause why the money or property should not be attached in lieu of arrears and or future maintenance. Due to the possibility of future default amounts arising because of delays in the execution process, provision is also made for the automatic adjustment of the amount to be attached in the case of warrants of execution, the attachment of emoluments, and the attachment of debts, on the strength of an affidavit under oath or an affirmation by the applicant. Furthermore, specific provision is made for execution against the assets of or income from a trust when an order to pierce the veneer of a trust has been made. Lastly, we get to Chapter 8, General and Supplementary Provisions. Currently, Section 15.3a of the Maintenance Act provides that the duty to maintain their children rests upon both parents, pro rata, according to their respective means. No formulas are provided on precisely how an award is to be calculated, and maintenance awards are discretionary in the sense that the court will consider what is fair and just in the circumstances of each case. In maintenance court proceedings, Regulation 3 under the Act requires both parties to submit the necessary documentary proof of the financial position so that it can be investigated. In addition, Regulation 2 prescribes that Form A of the annexure to the Act should be completed by the applicant. The purpose of this form is to make it possible to assess the needs of or total expenditure on the child in the applicant's household. To calculate the respondent's share of the child's needs, his or her gross income is then divided by the total of both parties' gross income, and lastly, his or her share is then multiplied by the total amount of the needs of the child as apparent from Form A to determine the maintenance award. As it often happens that the maintenance awards determined in this manner cannot be afforded by respondents due to their other living expenses, some magistrates propose other formulas. It's clear that the Act is open to interpretation by maintenance court officials and that children who receive maintenance are at the mercy of these officers who sometimes make arbitrary awards in terms of the Act. Nonetheless, in terms of the responses received to the question in the issue paper as to whether a formula-based maintenance system should be introduced, the general sentiment was that the discretionary system that's currently in place would provide the best results in a country where a vast number of people live below the poverty line. Although child support calculators, such as those applied in the UK and Canada, may work well in first world countries, they're often based on principles which are foreign to an African context. For example, the Canadian tables studied in the discussion paper only take the non-resident parent's income into account, whereas Section 15 of the Maintenance Act clearly states that the duty to support their children rests on both parents. In the African culture, extended family members may also have a duty of support towards children. In our research, we could not find a single African country which makes use of child or spousal support formulas. The Commission nonetheless thinks that guidelines may be of assistance, and accordingly, Section 44 of the Maintenance Act is to be amended to enable the Minister of Justice to develop and prescribe guidelines based on both parents' income and means to assist with the calculation of maintenance awards in respect of children. And that's it from my side. Hope you could have seen the PowerPoint presentation. Hello?
That's why I gave you a little bit of leeway with time. Thank you very much, Leentjie. I think that set it out really nicely. What the suggestions are for from the South African. Kan jy my nou hoor? Ja, ons het gehoor en ek sê baie dankie, dit was regtig goed. Ek dink it really set very much the Commission is, although everybody might not agree with your solution, but that's good. And I think one of the persons that might give you a little bit of critique is coming up next. I don't know if you know Eugene Opperman. Yeah. I saw that, yes, wonderful. No, I do know, and I do know that you still, that's cool. Ladies and gentlemen, our other keynote speaker is Eugene Opperman, who most of you have seen around here. He is, I don't quite know how to introduce you, Eugene, because I think you are Mr. Maintenance at the moment with everything that you're doing, not just officially, you know, as an attorney with much experience in the small claims court and so on and so forth, but also what you do with all the knowledge and your presentations and books and so on online that really, I think, makes a huge difference in South Africa. So I'm really looking forward to hearing what you have to say. And I'm sure Leentjie will also sit up straight. Let's see if I can get you up here. There we go. Can you believe it? I got it right. Hugh, your time starts now.
Thank you. Thank you so much. Maybe I can just put it in presentation mode.
You could do what.
There you go. Thank you so much for the opportunity to come here. It's quite a pleasure in just sharing our knowledge and our experiences with regards to that. Yeah, thank you for the introduction as well. I'm passionate about family law. I'm a family law practitioner. I've been doing so for the past 23 years. And for a man standing here talking about predominantly women's stuff, the struggles of women in courts is quite an honor. And it's quite humbling. I've been to most of the courts throughout South Africa. I've seen it all. I've seen tears. Carmel, I mean, you had me in tears. I've seen the heartache. And the topic for today was, you know what, is there some light at the end of the tunnel? And you know what, there is. Let's not beat around the bush. It's going to take some time. Rome wasn't built in one day. Just as a matter of interest in as an introduction on is there hope? There was a case handed down yesterday by the Gauteng High Court, SFS versus AJS, where it dealt specifically with a couple of issues. The one was arrear maintenance. These people were in a divorce settlement, an acrimonious divorce settlement. One of the issues the key issues that had to be addressed was arrear maintenance, which is a plus because that is some case law for us dealing in maintenance. It also spoke about the financial strain and the health issues, unpaid university fees, and the legal inaction because the attorneys, they were just dragging their feet in this whole procedure, and there was cost orders against them. So that was a win for maintenance. The respondent was given 3 days to pay 274,000 Rand or go to jail for 6 months. So one up for the judges in the Gauteng High Court. Right, turning to the presentation today, I'll be addressing the portion of mediation that was dealt with by Prof Leentjie with her research team, the South African Law Reform Commission, and I will be addressing a couple of issues, a couple of questions. One of those would be, should mediation be formally incorporated into the maintenance system? Prof Leentjie alluded there to, should mediation be mandatory or voluntary? Who should provide the mediation services? Who should pay for the mediation services if they are rendered? At what stage should child maintenance be delivered or done? And then lastly, a question that wasn't addressed in one of these papers, although it was mentioned in some of the work groups and the working sessions with the South African Law Reform Commission, is what exactly should be mediated. Now, if we look at just the overview of the maintenance history, we had the Maintenance Act in 1998. Then we had the very familiar case of Ballantyne versus Ballantyne, where the court said a couple of years after the enactment of the initial Maintenance Act, that the court found that despite the good intentions embodied in the Maintenance Act, logistical difficulties in maintenance court mean that the maintenance system does not function effectively. So right in 2003 already, the legislation was criticized because it was not working. Subsequently, there was a panel and they did the Project 100 in 2014 and the Maintenance Act was amended. What I'm trying to say is that the Maintenance Act should be fluid and it should be as we evolve, we should use different approaches to maintenance to adapt to the circumstances in South Africa. Then there was the amendment regulations that came into play in 2017. And then lastly, the paper 157, which is the latest one, which is leading up to the amendments of the Maintenance Act, which is dire needed in order to keep up with the times. So maintenance in general, referring back to the Ballantyne case, the court said that the courts have a particular responsibility in this regard and are obliged to forge new tools and shape innovative remedies if needs be to achieve their goal. And that was said by Judge Yvonne Mogoro, and that was absolutely brilliant. We need to use innovative ways in order to overcome the obstacles of the Maintenance Act. And one of those obstacles is the use of mediation. That could be seen as an innovative tool that could be used in the maintenance realm. So should mediation also be formally incorporated in the maintenance proceedings? Prof Leentjie alluded there to, and absolutely yes. In trend with the worldwide movement to alternative dispute resolution and of course, the impact of COVID as well, where we could not have interaction with people, the use of alternative dispute resolution techniques are definitely to be preferred. Also with regards to backlogs, we know all the advantages of mediation, and I'm not going to regurgitate on those. Mediation is referred to in a couple of sections, people dealing specifically with family law. It's referred to in the mediation in certain Divorce Matters Act, the Court Annexed Mediation, Children's Act, the Recognition of Customary Marriage Act, the Child Justice Act, as well as the Rule 41A and the subsequent one in the Magistrate Court, where mediation is preferred. So it will be done. It will be done and it will be included. And it is definitely the view of the South African Law Reform Commission that it should be formally incorporated and it should be formalized, encouraged, and improved to ensure future successes. A couple of concerns with regards to that is that, you know what, we could include that in our act, and that is fine, and that's 100% correct. But the nitty-gritty, the workings thereof, needs to be regulated, and clearly drafted regulation should be formalized, including public participation as to the practicalities and the real life experiences of people. It's no use. You have academics, you have judiciary, you have people sitting in high-ranking positions, earning probably bigger salaries than most attorneys do, and they make laws for the people on the ground. I invite them to come with me and go to a maintenance court and stand in a damn queue for 6 hours in the rain, no shelter, no food, to get to the front of the queue and be turned away. That is the participation that is needed in order to properly formalize regulations, specifically when it comes to mediation. There needs to be a centralized regulatory body for mediators. We have NAPFAM, which is the umbrella company for umbrella institution, but it is a voluntary organization for private mediators. So now you would have mediators running around courts, doing mediation, not knowing, can I swear? Jack shit. What to do and how to do it, because they had 5 days of training, and now they enter into an arena where you work with people, you work with the emotions of and sacredicity of the family unit, you work with children. So proper training needs to be done, and there needs to be a centralized regulatory body, very similar to the Legal Practice Council, so that if mediators overstep their boundaries, if they go out of line, that they could be disciplined and be removed from the role of mediators. Because now, as it presently stands, is that if you are a NAPFAM member or a FAMAC member or social justice member and you are being disciplined, you can still go out and say, you know what, I've been disciplined, okay, right, so I lose my membership with these institutions and I just continue to practice as a mediator. There should be a system where that mediator, that rogue mediator, is removed completely of practice of mediation. Should mediation be mandatory or voluntary? There's an increasing tendency to make mediation mandatory, thinking about the Children's Act as well as certain other acts. And this was discussed in paper 148, Project 100, ADR in Family Matters. And then as a preliminary recommendation, they make provision that for mandatory mediation in family disputes before the parties may actually even approach the court. Now, obviously, if you want to enforce something upon someone, because one of the core elements of mediation is the voluntariness thereof, it's the voluntary participation. The question arises that could that be seen as unconstitutional to force someone to enter into mediation? Now, there's a difference between referring the matter for mediation, mandatory referral, and mandatory participation, and we'll get to that in a moment. But the constitutionality thereof would be addressed probably by the South African Law Reform Commission in Project 94, which deals with generic mediation. The view of the South African Law Reform Commission, as I see it, is that the referral of the parties to mediation after the initial investigation of the application should be mandatory. It is recommended that subsections 6.3 and 6.4 of the Act be amended, which Prof Leentjie also alluded to. So the referral would be mandatory. The participation thereof might not. The changes envisaged or proposed by the South African Law Reform Commission, Section 4A, is that after the investigation, the maintenance officer must advise the parties. So there's an obligation upon the maintenance officer to advise the parties that they have to try and resolve the matter through mediation through a couple of routes. The one would be through a private mediator where the costs are shared equally, or through a community-based mediator. The cost would also be shared equally between the two participating parties. And then lastly, the maintenance officer. And then maintenance or the mediation must be concluded within a period of 30 days unless the mediator provides the parties with a reasonable explanation for the delay. And this is where my problem comes in. Because one of the problems that we experience in maintenance courts are delays. On average, on my Facebook group, I also see that. On average, it takes about 9 or 10 court appearances before the matter is even attended to. So there would be delays, and that is totally wrong. So now it's very noble, 30 days. But now you would have a situation, unless the mediator provides the parties with a reasonable explanation. If the parties choose to go for a private mediator, and the cost would be shared equally, what would be the one delay reason why the mediation would not take place within 30 days? I don't have money, no money. There won't be money. So what would the mediator do? The private mediator, depending on income from the mediation, would say, you know what, that would be considered a good reason to postpone the matter for another 30 days. And another 30 days, up until a stage that one or both of the parties have the funds to pay for it. Isn't that just adding another layer to the already overburdened maintenance system? Wouldn't that give the parties just another excuse to delay and not fulfill their maintenance obligations? Just another point that I need to raise here is that if the parties do not agree on a private mediator or a community-based mediator, that the onus would fall upon the maintenance officer to do the mediation, and that would obviously be free of charge. A couple of concerns there. A mandatory mediation can only be authorized by enabling legislation, which is quite obviously because we need to force the people. It needs to be enabled by legislation. Then there's also the question about the mandatory referral versus the mandatory participation. You know what, you can take a horse to the water, but you can't make him drink unless you take 2 bricks and you hit him from behind on certain parts of his anatomy. But that's the only way. So you can get the parties to mediation, but you can't make them mediate. You can't make them participate in the whole system. 30-day period, yes, unless it might cause unreasonable delays, additional layers there too. And then there's also the suggestion that prescribed fees needs to be laid down for mediators, private mediators, community-based mediators. Because at this stage, I've seen mediations being done for as little as 500 Rand, running up to 2,000 Rand per hour. So there needs to be uniformity in order to gain trust in the whole system of mediation. Who should provide mediation services? That's already self-explanatory, the private mediator, community-based mediator, and then, of course, the maintenance officer dealing with that specific matter. And it was quite strange why the South African Law Reform Commission added the wording, the maintenance officer dealing with the matter. Because we know that maintenance officer gets rotated as I rotate my damn underwear. chances are that you'll find the same maintenance officer there within a month's time is scarce. Because either they're not available, or they're on course, or they are playing solitaire on their computer, or they're just not doing their job. And that might create a problem, specifically that wording, the maintenance officer dealing with the matter. It should only be a maintenance officer, because if there's no maintenance officer available in terms of section 4, any prosecutor is deemed to be a maintenance officer, especially in the rural areas. So maybe there is some wording that needs to be looked at. And I don't know what I just did.
I don't either.
The presentation just went gone. Oh, there it is. Sorry. Yes, that's just an amplification of what I just said. Who should provide it? It should be include a wide range of public, private, and community-based service providers, obviously at the expense of the parties concerned. Still staying with the who should provide these services, there should definitely be a clear scope of practice defined for the private mediators as well as the community-based mediators, so that they do not overstep their boundaries. Now, there's a tendency nowadays of pro bono services, mediators doing pro bono services at courts, which is noble, which is absolutely great, but there's no continuity, because you know what, it's sometimes in many instances, it's not sustainable, because that specific mediator doing pro bono work might not be available on the next day or the next day or the next day. The operations in court are dealt with by the Director of Court Operations in the different provinces, and they have to oversee what is happening in courts. And there are some pushback and some resistance from some of these officers, because they realize the need for a regulatory body, because they cannot, as directors of court operations, they cannot allow anyone to go to court and just do whatever they like and offer mediation services, even if it's for free, because they still have the responsibility for the protection of the people in their specific courts. So there are some resistance, and that's why the only way that could be alleviated, so that we could take hands with the Department of Justice, would be to have a regulatory body that can enforce the scope of practice as clearly defined for the private and for the community-based mediators. Obviously, suitably qualified people, training standards. I follow quite a number of people abroad with regards to training, and I also had insight in most of the institutions offering mediations, their training material, and they offer a 5-day course. The tendency overseas, specifically in Singapore, for example, Balkan states as well, UK, before you can be a qualified mediator, you have to have 200 hours of mediation training. So now 200 hours as opposed to 5 days of mediation that we do in South Africa. Are the people equipped therefore? I don't think so. Obviously, also the maintenance officers dealing with that, because that would be the event in most cases, that the maintenance officer would need to deal with these type of people, because they cannot afford to pay for private mediation or for the community-based mediators. And then the mediators or the maintenance officers needs to be properly trained. Would they be properly trained? And that is a big question. That is a big ask, because you know what, apart from having some psychology training to pick up, like Felicity mentioned, the behaviors, the patterns of domestic violence and so forth within a mediation setting, will they be properly trained? Who will train them? And how will the training be enforced? Because to expect from maintenance officers to take over the role of private mediators and community-based mediators would be ridiculous, because they simply don't have time. They don't have time to spend 2 hours on a mediation in the day when there's 30 people standing outside their door wanting to claim maintenance that needs assistance. They cannot do that. It's only one maintenance officer. Who should pay for the mediation services? Yes, the proposals for the South African Law Reform Commission is quite clear. It should be shared equally between the parties, unless the maintenance officer is dealing thereof. Now, in context, one should realize that, you know what, we work with indigent people, vulnerable people that do not have money to pay for these type of services. Bringing it back to the private mediators as well, there's 2 lines of thought, 2 lines of argument. The one is, you know what, you really cannot afford that. On the other hand, you want people to pay some form of a contribution in order to get their commitment to the mediation. The South African Law Reform Commission said that in their proposals, the party should pay for it at their own costs unless it's offered by the maintenance court officials. I've mentioned that. At what stage? Prof Leentjie mentioned that basically at any stage, the matter could be referred to mediation. Some of the recommendations that they made was quite interesting. One was that if the parties mediated it outside court, that it could be reduced to writing and obviously be submitted electronically to court. Now, that's a very noble idea, and I think that's also very brilliant. We have the system at this stage where the parties could complete a J214 consent form, and then the matter could be made an order of court in terms of Section 17 of the Act. So those systems are available to have it electronically submitted. I think that's a little bit of overreaching, but yeah, it is definitely a noble idea. Now we come with a question, and how, I don't know how we're doing on time. 4.5 minutes. 7.5 minutes. So what should be mediated? So if one looks at the model of mediation, which encompasses confidentiality, voluntariness, empowerment, the neutrality in the unique situation. If we compare the mediators to maintenance officers to courts, it is quite clear that the private and the community-based mediators would be in a better position to offer this kind of services. The only drawback would be the access to courts and the access to funds for the parties in order to engage the mediation. Obviously, what should be mediated, and that was not addressed. Obviously, disputes where about the financial position as not allowing for an increase of maintenance, or where what you want to investigate the other parties or a party's financial position that says, but it actually warrants for an increase or the decrease. The disputes of paternity, where one alleges that he is not the biological father and do not bear the onus of paying maintenance, that could be mediated, and also the failure to pay maintenance could be mediated. The intersection with other modalities or other instances like domestic violence cannot be ignored, especially when it comes to mediation of maintenance matters. Because there is in Section 2B of the amendments of the Domestic Violence Act, there is an obligation of any person to report domestic violence and to provide information. If you are in a mediation setting, and we've discussed this at the FAMEC conference a week ago, if you are in a mediation setting and you listen to the parties and as you progress through the mediation and you find out, it emerges that there is some form of domestic violence in that family unit or that family structure, there's an obligation upon you as the mediator to stop the mediation and to refer the matter to either a social worker or to the police. Because there's an obligation upon you in terms of Section 2B of the amendments of the Domestic Violence Act to report that matter. And this might seem problematic for most mediations, because now you sit with a dilemma of the voluntariness, the confidentiality of the whole process of mediation, and it's not done. What happens, for example, if there is a domestic violence order against a person, but you now are forced into a mediation setting? How will the mediators deal with that? What if one of the magistrates said you are not allowed to come within 50 meters of that person, or you're not allowed to talk to that person? If that is a court order, now you are forcing people to go into mediation. How will that be dealt with? Obviously, then lastly is the adequate training that needs to be addressed. And the knowledge of other modalities like in psychology or behavioral science. You see, but you know what? You can pick up these type of behavioral markers that might indicate domestic violence and so forth. That is basically me in a nutshell. Thank you so much.
That's great. Thank you very much, Eugene. Sometimes I get the feeling more questions than answers. It's time for a little bit of a comfort break. We're supposed to start at 11, but shall we make it 5 minutes past 11? Would that be in order for everybody here and online? So we'll start again 5 past 11. Thank you. Camera on.
No, it's okay. As you thought. Als ik nog besluiten weer, ja. Ek dis al wat ek kan aanneem. Okay. Nee, dis fijn, dankie my Frankie. Eers vanmiddag. Yes, ja. Nie myself hier coach na die universiteit. Well, ek moet my presentation doen vanmiddag. Ja, hoekom wat wil jy doen? Well, ek kan maar ry, dis so, wanneer maar ek weet, dis die kaart klaar. Well, okay, maar dan kan jy mos ry. Ja. Ek dink ek kan. Ons vriend dan vra van jy bring die vrou, die weet die geld. Of ek se vir gee. Okay. Ja, vir my sê, okay. Alright, okay. Yes, okay. So okay. 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 Ek vind dat jou dit is jy wat shame. Eerste keer dankie my. Okay, sien later van kies kyk waar. Ja. I'm so happy. You have no idea. I'm so happy. I'm so happy about me happened. Now that the seasons of 6 and Mitzi all kind of her now there. You know, she saw the hands. I think she didn't have it before.
Van Hannibal. Soos 'n Hannibal Lecter.
Ja. Ek het my dogter dit so gekyk.
Well, okay, nou ek sien sy het nou vir my 'n dingetjie oopgemaak.
Eerlikheid, dit lyk ingewikkeld.
Maar weet jy, hulle dink hulle maak dit vir my makliker, né? En dan maak hulle dit eintlik vir my moeilik. Want hulle dit
Altyd ons moet hierso lê.
So kom ons maak nou oop. EF drive G. Dink is hierdie ene. Marita Kreer, daai een. Okay. Kom ons sê copy. Is die nou met sê hy hierso vir my nou moet ek hom waar laat lê op die desktop op maintenance. PowerPoints. Since there was method in a madness.
Ja, as hy.
Okay, en jy is jy volgende?
Ek dis eers Bridget, dan
Bridget en dan jy.
Amanda.
Okay, goed. Nou, ek net hierso kyk wat ek hier kan afhaal. Dis die presenters. Bridget wat so lekker wie is hierdie ene? Dit is Bridget se. Okay. Gaan ek nou jou nou oopmaak ook. Daar's dan nie meer so baie hier nie, jy weet, in die begin was dit 'n bietjie Nee, ek sukkel, weet jy, ek was so bederf deur my kinders toe hulle nog in die huis is en toe bogger of hulle almal uit want hulle word mos nou groot.
Ja, dis dan jammer.
Dis baie jammer,
Sit dan
né?
net jy en jou ma hoor.
Ek en my ma. Ja, my ma's 90 en sy was heeltemal goed gewees tot so 6 maande terug. En nou die demensie en dis verskriklik om dit te sien. My kleinseun is gebore in Hong Kong, my tweede kleinkind en ek het vir 'n week weggegaan van die 19de tot die
Sit dan op jou profiel.
Ek weet nie, dit sal seker ja. En daai week het sy het geval.
Ag nee.
En sy het net nie
weer
reggekom nie. En dis wat het sy
trauma weer
glad nie my broer herken nie. Dis vir hom, sy het nou die dag toe sê sy vir my, sy's 'n ou verpleegster, 'n besondere ou verpleegster. Sê sy vir my, sy weet nie pas Marita nou nie, maar sy's so bly as sulke goeie verpleegsters wat na haar kyk. Nou lag ek nou sê vir ma, dis die grootste kompliment wat ma my nog ooit gegee het, dat ma dink ek's 'n verpleegster. En dan lag ons daaroor, want jy weet jy moet. Maar dis soos om nou dit is ek het gelukkig ons het die diensentrum hier. Ek weet nie weet van die diensentrum nie. Nou hulle kom bad al 3 oggende week. Ons stuur verpleegsters huis toe. En ek het nou keer vandag daar van 8 tot 8. Dis nou die eerste keer so lank wat. Nou dan die dokters ou aan, dan die dokter het na ander pelle se ma's gekyk en so. En sy kom in en alles het my sê is Marita, hou worry gaan. Jy weet, dis hoe my skoon is op maar daai, jy weet, sê nou iets gebeur of maar weet jy, my ma was haar hele lewe lank lief vir my. Ek sal haar enige doen. Absoluut. Maar weet jy, sy is by oomblik is sy in die 40er jare. Jy kan sien hoe my pa was altyd 'n issue en toe, jy weet, en so, maar sy's nou letterlik, sy was in die 40er jare, vroeg 50 is sy nog Engeland toe. Sy is nou daar vir my, sy's nou waar sy was op skool en vreeslik
saam met ons.
Absoluut. Ek leer meer van die groot familie sekret wat ek nooit geweet het. My ma se suster se oudste kind is nie haar man se kind nie. En ons vermoed maar lank al want Greta het 'n oogsiekte wat geneties is. Niemand anders in die familie weet. So almal weet, maar nou weet ek dis nou sit ek met die lewe sê vir Greta of sien vir die kan ek sê nie. Nee, dit is nie Greta weet, maar ja, dis hard.
Sy weet sy jou.
Nee, wel nee. Sy weet nie, sy weet sy's nie haar Jans nie, maar sy weet nie.
But I was interested in I know he's going to tell me that
Okay, ladies and hello. Morning. Hello. Can the people online hear me? Can the yeah. Hello. Hello. Moet nou nie vir my so sê nie. Hello. Hello. Can the people online just give me an indication whether you can hear me?
Can everybody hear me now? Okay, great. Thank you, Elsje. Our next speaker, sorry for the few minutes late. The people are still coming in, but they can come in their own leisure. Our next speaker is Professor Bridget Clark. I think the fittest academic in South Africa. But apart from that, she is one of the experts in child law in South Africa. She's been also an academic for many, many years. She has published quite a lot, and children rights is her issue. So, Bridget, your presentation, I will put it up now for you. There we go. Just share it. There we go. Can you see that slideshow from the beginning? Okay, Bridget, can you hear me? Hello? Can you hear Bridget? I can't hear Bridget. Bridget, are you there? Bridget Clark, there we go. Bridget, we can't hear you, so if you can please just try and unmute. We seem to be having a problem with Bridget. Bridget, mute. No, we don't. Bridget? I think what we will do is, if we're battling to get Bridget, what we will do is we will then move over to Marita, and then hopefully we will sort out Bridget a little bit later to do a presentation. Bridget, if you can hear me, that would be, that's great. Sorry. Marita, I just want to make sure that you are shared and that we not share that one. That. Hello. There we go. Oh, at last. Okay, your time starts in the next minute or so. Okay, can you all see Marita's presentation? Please just say.
No, we can't.
Can't see it. Okay.
Online.
Yeah, not online.
Are we not online?
Mm-mm.
Can only see you.
Oh. We seem to be going. Share. Let's try again. There we go. Can you see it now? Okay,
Yes.
perfect.
Yes, great.
There it's gone again.
Off again.
Yes.
Come on. You think it's something to do with the signing in? Let's go there, share. Is it on again? Okay, let's not fiddle at all. You're in charge.
Morning, everyone. You're probably wondering what this topic is doing in a colloquium on maintenance. There is a reason, there is method to my madness. I had to come up with a different topic rather swiftly when I realized that I had the same idea as one of the other speakers, notably Bridget. I will therefore zoom out slightly from the topic of the day to the umbrella concept of parental responsibilities and rights, without which there cannot be maintenance, can there? And I'm specifically speaking about the parental responsibilities and rights in respect of children born as a result of artificial fertilization to permanent life partners. Thanks, Marita, for your indulgence. I will use the abbreviation IVF for in vitro fertilization instead of artificial fertilization in this presentation. Oh.
Marita.
Yes,
Dieselfde het met my gebeur. Ek dink daar's 'n ding op die rekenaar, pyltjie wat jy moet druk. Hy gaan nie aan op die gewone manier nie.
So die pyltjie werk ook nie. See from the
Marita, ekskuus, ek is die laaste persoon om enigiets hieroor te sê, maar ek het gister iets uitgevind. As jy gaan share weer aan die bopunt van jou skerm, share jou PowerPoint weer?
Dit lyk of hy nou aangaan. Dankie.
Ons sien nou.
Maar ons kan hom nie sien nie.
Ons sien nou niks nie.
Jy moet hom share as a Teams presentation of suites.
Okay, ek sê vir Marita, sy die muis in die hand.
So aan die bokant van die lyntjie wanneer hy oopgaan is daar ietsie so wat sê share as a Teams presentation of so 'n hytjie. Ek weet nie of dit net op my rekenaar is nie.
Maar jy share nog nie.
Nou help ons tog nie asseblief. Okay.
Yes.
Dankie, Leentjie. In this presentation, I will consider the recent Constitutional Court judgment in VJV versus Minister of Social Development. I've added the BCLR reference on this second slide. It was reported in October. Okay. Okay, los nou alles. Okay. So, yeah, there's the reference for BCLR. The court was asked to confirm an order of the Gauteng Division of the High Court, declaring Section 40 of the Children's Act unconstitutional to the extent that it excludes permanent life partners. There is the reference of the High Court judgment. The High Court held that the provision unfairly discriminates against permanent life partners on the basis of marital status and also violates the right to dignity of unmarried persons who had children by means of IVF. The court held that the rights of children born in these circumstances are also violated, specifically their right to family and parental care and their right to have their best interests considered paramount. Finally, the High Court found that Section 40 did not discriminate on the basis of sexual orientation, as the word spouse included civil union partner. The applicants, who were two women in a permanent life partnership, had a long-standing desire to have their own children. Their dream was fulfilled by means of IVF when the first applicant's ova were fertilized with donor sperm cells, and the resulting embryos were transferred into the uterus of the second applicant. A successful pregnancy ensued, and the applicants had twins. Now, if we look at the current Section 41A, it provides that whenever the gametes of any person other than a married person or his or her spouse are used with the consent of both spouses for the IVF of one spouse, any child born of that spouse as a result of this IVF must for all purposes be regarded to be the child of those spouses, as if the gametes of those spouses had been used for such IVF. In terms of Section 40, subsection 2, any child born of a woman following IVF is for all purposes regarded as her child, with the exception of children born following the IVF of a surrogate mother. So in these facts, it would be the first applicant, the birth mother, would then be regarded as the mother. Except in cases of surrogacy, no right, responsibility, sorry, I made a mistake, it was the second applicant. No right, responsibility, duty, or obligation arises between a child born as a result of IVF and any person whose gametes were used for such IVF or the blood relations of that person, except if the person is the woman who gave birth to the child, or if the person was her husband at the time of the IVF. Sorry. In VJV, Justice Colloquium painted the following picture of the impunged provisions with reference to the facts. The children are regarded as the children of the second applicant, as she was the one who gave birth to them. It's also called a birth mother or even a biological mother sometimes. The first applicant has no responsibilities and rights, even though the applicants are permanent life partners who jointly decided to have children and went through the IVF process together using the first applicant's eggs. So she is genetically related to the child, but she is not considered the child's mother. The provisions therefore only recognize parties in a marriage as the parents of a child born through IVF and not parties in a permanent life partnership. Consequently, if an unmarried heterosexual couple have a child through IVF and donor gametes are used, only the woman in that relationship will acquire responsibilities and rights in respect of the child. Similarly, if an unmarried female same-sex couple have a child through IVF and donor gametes are used, only the woman who gives birth to the child will be assigned responsibilities and rights, and not the other woman in the relationship. These consequences will apply regardless of the nature of their relationship and their commitment to each other, and irrespective of whether these consequences will be in the best interest of the child. Section 40 therefore singles out marriage as the only relationship that allows parental responsibilities and rights to arise in respect of children born as a result of IVF. With reference to the dissenting judgment of Justice Sachs in Foulkes versus Robinson, Justice Colloquium, in a unanimous judgment, found that the answer that those who are excluded may effect their inclusion by getting married, so the choice argument, is no answer at all. The reason for this, he says, is that it negates the freedom of choice to marry or not to marry. It's also problematic in cases where those in permanent life partnerships may, for some or other reason, not exercise that choice. And this was recognized in Wanya versus Master of the High Court. Justice Colloquium held that by automatically assigning responsibilities and rights to married parents of children born of IVF, but failing to assign such responsibilities and rights to unmarried parents, two categories of persons, namely married and unmarried parents, are treated differently. The court examined the impact of the discrimination, concluding that the impact of the discrimination based on marital status is far-reaching. It sends the message that the choice made by permanent life partners to become parents is less respected than the choice made by married partners. This devalues the applicant's relationship and it impacts their dignity. Consequently, the discrimination is unfair. The court next considered the question whether Section 40 constitutes unfair discrimination on the basis of sexual orientation. Now, you'll remember the High Court said it did not. When two men in a permanent life partnership wish to conceive a child, they would not rely on Section 40. Section 40 deals with artificial fertilization. Neither men can be artificially fertilized. Instead, they would rely on surrogate motherhood. Lesbian permanent life partners who want to have biologically related children, on the other hand, have no other alternative but to use IVF. Purely on the basis of their biological reproductive limitation, the court says, their parental responsibilities and rights are exclusively governed by Section 40. Therefore, lesbian life partners are disproportionately affected by the differentiation caused by this provision. As there can be no legitimate government purpose for the differentiation, it follows that Section 40 indirectly discriminates against the applicants as lesbian life partners on the basis of their sexual orientation. The court held that Section 40 also limits the applicant's right to dignity, which includes family life, as they are unable to become parents due to the choices they have made. Finally, the court considered the paramountcy of the child's best interests and held that the best interest of the child should be at the forefront when considering whether to assign responsibilities and rights to parents. Children have the right to a beneficial legal relationship with both parents, in terms of which such parents are obliged to care for them, maintain contact with them, act as their guardians, and contribute to their maintenance. As Section 40 fails to recognize the first applicant and others in her position as a parent, the children born in these circumstances are deprived of automatically assigned and legally enforceable parental responsibilities and rights. Further, the court held that differentiating between children based on the status of their birth is not consistent with the best interest of the child principle. Following a comprehensive justification analysis, Justice Colloquium held that the limitation of the applicants and their children's rights is not justifiable in terms of Section 36 of the Constitution. The impunged provisions could therefore not withstand the constitutional challenges directed at them, and the High Court's order of unconstitutionality was confirmed. In keeping with the doctrine of objective constitutional invalidity, the court held that the declaration of constitutional invalidity should apply with retrospective effect from the 1st of July 2007, when Section 40 came into operation. However, the court suspended its operation for 24 months from the date of this order, which is 29 June 2023, to afford Parliament an opportunity to remedy the constitutional defects giving rise to the constitutional invalidity. The court also provided an interim remedy by way of a reading in order to deal with the impunged provision while Parliament effects the amendments. The court ordered the reading in of the words or permanent life partner after the words spouse and husband, where such words appear in section 40, and then the same applies to the words or permanent life partners after the word spouses. The court did not consider it necessary to provide a definition of a permanent life partner. And this was actually canvassed by the Center for Child Law. In this regard, the court referred to the approach in National Coalition for Gay and Lesbian Equality versus Minister of Home Affairs, where the Constitutional Court listed factors to be considered to establish the existence of a permanent life partnership. If Parliament does not comply with within the 2-year period, the reading in order will continue to exist, either permanently or until Parliament effects the amendments. Now, this is important. For the period of 1 July 2007 to the date of the order, the reading in order will only apply to persons who were permanent life partners at the time of the artificial fertilization if they invoke the benefit of this order by means of a written declaration signed by both of them. What is the effect of this decision? When a woman in a heterosexual or same-sex permanent life partnership conceives through artificial fertilization using a third-party donor gametes from 29 June 2023 with the consent of her permanent life partner, the child will, for all purposes, be regarded as the child of those life partners. If the artificial fertilization was done between the 1st of July 2007 and 28 June 2023, the child will be so regarded if the life partners invoked the benefit of the order in VJV by co-signing a written declaration. I just have a few concluding remarks. Interestingly, despite the court's decision that Section 40 also unjustifiably limits the applicant's rights to dignity and the best interests of the children, these rights were not specifically mentioned in the court's order in paragraph 97. Here, the court only referred to unfair and unjustifiable discrimination on the basis of marital status and sexual orientation. As explained above, the Constitutional Court in VJV held that children born following IVF to permanent life partners are regarded as the children of those life partners. The court did not consider the question whether these children are regarded as children born of married or unmarried parents. I think, let me take you back to the J decision, just to make it clear what I'm trying to say here. In J versus Director General, Department of Home Affairs, this was in 2003, the court confirmed the constitutional invalidity of Section 5 of the Children's Status Act. That was the predecessor of Section 40. Now, Section 5 provided that a child born as a result of artificial fertilization in similar circumstances to those envisaged in Section 40 of the Children's Act shall, for all purposes, be deemed to be the legitimate child of that woman and her husband or permanent same-sex life partner. And the Constitutional Court in J found that Section 5 discriminated unfairly against same-sex life partners on the ground of their sexual orientation, and that the discrimination was unjustified. Given the absence of a similar phrase, so the Section 5 of the Children's Status Act says legitimate child. Section 40 just says a child, or the child is considered to be the child for all purposes. So in the absence of a phrase like, nowadays we would call it a child born of married parents, not a legitimate child, it could be argued that children born as a result of the artificial fertilization of women in permanent life partnerships using the gametes of third-party donors with the consent of their life partners will be regarded as children born of unmarried parents, even after the decision in VJV. If this is indeed the position, it would discriminate unfairly and unjustifiably against children born in these circumstances, on the basis of the marital status of their parents. This is in my view. The Constitutional Court found in Center for Child Law versus Director General, Department of Home Affairs, that differentiating between children on the basis of their status as being born of unmarried parents is invidious and unconstitutional and contrary to the best interest of the child principle. Now, I realize that this argument of mine can be seen as a bit academic. I am an academic after all. But I'm worried about the stigma that there will be still a stigma attached to these children. And it would have been good if the Constitutional Court could just make it clear that these children are regarded as children born of married parents. It will not make a difference for the partners themselves because they are regarded as parents. But it wasn't made clear with reference to the children. So I would just quickly like to refer to the Children's Amendment Bill, 18 of, and that's incorrect, I think it's 2020. Sorry, that slide's not correct. Clause 21 of this bill proposes to amend Section 40 of the Children's Act by replacing the phrase a married person or his or her spouse with a birth mother or her partner. The word husband in Section 43 is replaced with partner, and subsection 4 is added, which provides that partner in this section includes a spouse or a domestic partner. So it will be interesting to see if this bill is passed before the 2-year period set by the Constitutional Court lapses. I'm not holding my breath, but that's my story. Thank you. Sorry for the problems at the beginning.
Thank you very much. Let's see if we can get hold of Bridget. Let's just close this one. Let's see.
Can you hear me now?
I can hear you now. Hello.
Okay, I don't know what's happening there. I'm not on now, or whatever I was for 5 minutes.
No, that's all right. I'm sorry that we deferred you, but
no, that's fine. Absolutely fine.
It might just be my stupidity. In all probability, it is. Do you want to share from your side, or do you want me to share from my side?
Well, let me try. I'll share. Share screen. PowerPoint. Have you allowed me to share? Let's do it from your side. It's probably easier.
Okay, I'll do that. Go from the beginning.
So if you could do a slideshow.
Okay, there we go.
And hear me. Great.
We can hear you. Before you start, Bridget, I just want to introduce you very briefly. Bridget is another one of these senior academics that's been around for decades, working in family law and so on. So Bridget, we're really happy to have you here. You won the fight about this topic, as you probably didn't hear. Marita, I had to step aside. So we're all waiting with bated breath to hear what you're saying. Thank you. You've got the floor.
Thank you so much. If I could go on to the next slide. Can I get the next slide up? Thank you. So just briefly, the structure of my paper will be to look at the legislative and judicial approaches to the plight of cohabiting couples on separation or death. And I'll be focusing a bit on the relevant case law, particularly the constitutional case of 1 year, and a little bit on the draft marriage bill from the Department of Home Affairs, and contrasting that with the South African Law Commission Project 144 on the single marriage statute. So that's just briefly. Defining terms, as Riet said just now, there was no definition in VJV of life partner, but life partnership has generally been regarded as those who, regardless of gender, live together without being validly married or in a civil union. And in South African common law, of course, none of the consequences of the civil marriage ensue for a couple living as partners. But there has been increased judicial recognition of cohabitation in the context of same-sex life partners, particularly because before the Civil Union Act of 2006, such parties couldn't marry. So the courts bent over backwards, and cohabitation, of course, acquired a particular status, a kind of marriage-like context, but mainly in the context of same-sex couples. But the reality of opposite-sex cohabitation, as Elsje Bonthuys has pointed out so vividly in her articles, is that many opposite-sex are forced into life partnerships due largely to poverty and dependency. And numerous poor and often Black South Africans depart from rural areas, and we get this myriad of cohabiting relationships, dependency-based relationships, as Amanda Barrett refers to it. And such relationships are not really catered for at all in our law. If you could go on to the next slide, please. Internationally, of course, there've been various legislative approaches which have depended on whether, as in the United States, you focus mainly on whether you're going to protect the traditional view of the family and marriage, and then you just leave it as a laissez-faire that parties can just enter into contractual arrangements if they're not going to get married, or you have a status-based dependency default protection for such parties, which clicks in where the parties have been in a status of economic dependency with each other. Next slide, please. So there's various categories of cohabitation. On one hand, you've got the informed cohabitants. Those are people who live together and they've agreed, they've got a cohabitation agreement, they know what their circumstances are, and they don't want to get married, and they're fairly independent. They don't need they don't need to be dependent, or they don't need assistance or protection. Then you've got your uninformed cohabitants who believe they have rights. They believe that after a certain time they've lived together, they must have rights as common law spouse. They believe they've got an automatic entitlement to some sort of property at the end of a 20-year relationship when they've brought up the children, looked after the property, etc. Then you've got your reluctant cohabitants, which is where one party wishes to marry, but the other not, or else cannot. You've got your no-choice cohabitant, where they are, and that's particularly the category that Elsie talks about, and Amanda Barrett in her articles, and the report by Bonthuys and could see very interestingly details these intersecting inequalities of gender, race, and class, where people are involuntarily forced into this. There's no real choice as to whether they enter into those arrangements. Could I have the next slide, please? So whether you adopt a contractual approach, you say it's up to the parties, they choose, they're autonomous, or else you realize that there isn't a choice and you need to afford some sort of default status-based protection, as they do in Australia and Scotland. These are the two, when we look at it internationally, these are the two sort of different approaches that countries have taken. Next slide, please. Next slide, please. So if we look at the South African Law Commission single marriage statute discussion paper, the Law Reform Commission provided for the recognition of certain life partnerships. It's got 2 bills attached to it, but it still excludes a myriad of the relationships that I've been referring to. It defines life partnerships as those who cohabit and have assumed a permanent responsibility for supporting each other, which, as I say, is problematic in South Africa, where you see these myriad of often quite temporary but dependence-inducing relationships. And then you've got the draft marriage bill, of course, of 2022, produced by the Department of Home Affairs, which doesn't even mention life partnerships, although, in fact, next slide, please, the previous white paper did refer to the need to protect life partnerships, but that doesn't. So the position of opposite-sex life partners in relation to the Intestate Succession Act, that only at the present provides for the surviving spouse to a valid marriage. But in Gorey versus Culver case, they say that the word spouse should be interpreted to include a surviving partner to a permanent same-sex life partnership. And that was just before the Civil Union Act of 2006, 17 of 2006 was passed. But the courts continued in Loebscher versus Duplan to say, in 2017 case, to acknowledge the right of a surviving same-sex life partner to inherit on intestacy, despite the enactment of the Civil Union Act. But as Amanda Barrett pointed out in her brilliant article, they do say that there must be some sort of undertaking of duty, undertaking of support, which is also somewhat problematic, where one of the parties hasn't actually undertaken, but the other party is in a dependency producing position. And in terms of the claim for maintenance, that also only provides at present that a deceased spouse's estate, the survivor is the surviving spouse in a marriage dissolved by death or a partner in a civil union. And although that has been extended in various categories, has not been extended to opposite sex life partners. Next slide, please. And in fact, in Folks's case, Mrs. Robinson, Mr. Shandling, an opposite sex couple, lived together for a number of years. He supported her and she cared for him. Next slide, please. But in fact, as we know, although Judge Davis in the High Court said that the law was failing to recognize and protect opposite sex life partners, and it violated their rights to equality and dignity, and it disregarded, it therefore was unconstitutional. And he said that the words opposite sex partners should be read in to include that. However, in the Constitutional Court, the majority judgment of the Constitutional Court, as we're all familiar with, focused on the choice argument, the importance of marriage and family as societal institutions. And Keo commented that the spouse's rights are fixed by law, and that they haven't actually chosen. If they have chosen not to marry, well, they have to bear the consequences. So it focused on the freedom of choice which parties have, which, as we've said, in many cases in South Africa does not actually exist. Next slide, please. So Folks held it's not unfair to make a distinction, overruling what the High Court had said. Said no, Mrs. Robinson's dignity is not infringed, and this is if the legislature wants to change it, the legislature must do, but it must be corrected through the empowerment of the legislature as well. But at present, of course, there's parties have a choice. But what is interesting is the dissenting judgment of Judge O'Regan and Magaro, and they consider the impact of that majority ruling on those class of women who are in a dependency-inducing relationship. They are unable to look after themselves at the dissolution of the relationship. And the lack of bargaining power they have, they don't have that choice. And that was followed very much in the Bwanya case. Next slide, please. Because in Bwanya, Bwanya relied on the Paxeo decision, which also said that a partner, that it should be read in, that courts should allow an opposite sex partner to institute a delictual claim for loss of support against the wrongdoer. And they said, folks, it's not an obstacle to the development and extension of the dependence action. This is a delictual action which should be available to heterosexual life partners, even in that case where one partner was already in an existing marriage. And they said this is, in fact, a sui generis claim. It's not a spousal benefit as well. They focused on that. The general sense of justice means that we've got to extend this action. And relying on Paxeo and in Bwanya, if we go into the next slide, in Bwanya, of course, there was a two-pronged attack on the constitutionality of the exclusion of opposite-life partners from the right to claim maintenance and the denial of a right to inherit on intestacy in terms of the Intestate Succession Act. So there's a two-pronged attack. Next slide, please. And in terms of that, if you look at the relationship, the background of the relationship, very similar to the Folks case. Mr. Richard paid for all the household expenses. Miss Bwanya had cared for him. They were having to go, there were Lobola negotiations going on. They were going to go to Zimbabwe. She was from Zimbabwe to organize the Lobola. And just before all this happened, they were about to get married. Mr. Rush died. So the High Court actually had no problem in saying that she was perfectly entitled to inherit from the deceased partners, from Mr. Rush's intestate succession. But the court said we can't overrule, we're bound by Folks. We can't actually overrule in terms of the claim for maintenance, in terms of the Maintenance of Surviving Spouses Act. So it made a reading in for the Intestate Succession Act, but not for the Surviving Spouses Act. Next slide, please. So Buanya had applied to the Constitutional Court for confirmation of that High Court, and she appealed against the refusal to extend the maintenance to permanent heterosexual life partners, where the parties have undertaken the reciprocal duties of support in a sort of wide sense there. So next slide, please. But like I said, much as I'm convinced that the Volk's decision was wrong, I'm unable to jump and conclude that it was clearly wrong. But does that mean I must follow Volk's? I think not. And he did not follow Volk's. The majority judgment did not follow Volk's. They placed particular emphasis on the fact that on the choice argument. He noted that cohabitation is increasingly prevalent, and he said that all categories of families are deserving of protection. And you have to ask the question for choice. Is there in fact a choice in this case? Is there a choice to marry or not to marry? And that is a factual question. So following very much on the lines of Magoro and O'Regan's dissent, and also noting the development impact in Paxio, that it could no longer be fitting to distinguish the duty of support existing in the two types of relationship, a marriage and permanent life partnership, solely on the basis that one duty operates by law and the other has to operate by agreement. He said that's on the succession challenge, he said that the court said the words, after the word spouse, the word life partner should be read in. But the problem is that there is this idea that there has to be an undertaking of a duty of support. Those words are still there. What happens if there is no real undertaking of support by one partner? What if one partner suffered economic disadvantage from the relationship and the other has benefited? There are problems there. The maintenance as well. He said that the word life opposite life partner should be read in after spouse in circumstances where the surviving partner has not received an equitable share. But what is an equitable share is not defined there. Next slide, please. So Madlanga adopted the order proposed by Magoro and O'Regan in Volks, really. Didn't discuss what would constitute an equitable share. This means that while the Madlanga's order stands, there will be a clear distinction, in my view, between a surviving spouses and surviving life's partnerships as far as the Maintenance of Surviving Spouses Act is concerned. Next slide, please. So to conclude then, the South African legislature is now bound to offer more options to a substantial range of cohabiting couples or couples who, in my view, are in a dependency-inducing relationship. Then is a need for a balance between protective control by legislative guidelines and allowance for private ordering. So those parties who don't want anything, they don't to have to share. They just live together and they don't need anything on the dissolution. They don't need maintenance on the dissolution of the relationship. And there's got to be allowance for the different types, the 4 different types of cohabiting couples that I mentioned in the beginning. The recognition of the reality of the lives of many opposite cohabiting couples who fall into a statutory definition. They should have some sort of protection, and I think they should increase the discretionary powers of the court based on certain legislative guidelines, bearing in mind the diversity and flux of family life, as has been so brilliantly illustrated by many articles. I think 2 of Fatima Osman's articles as well. We need to move towards some sort of presumptive protectionist approach. Such as in Scotland, for example, they look at whether the relationship has produced an economic advantage for one party and an economic disadvantage for another party. So greater protection, I'm not saying exactly the same as marriage, but greater protection by the legislature to assist the courts in doing justice between the parties and any children of the parties. So looking at rather the dependency which has been produced and the economic advantage to one and the disadvantage to another. Thank you very much. Thank you.
Hello. Maybe you can't hear me. Amanda, can you hear me?
I can hear you. Can you
Oh,
hear me?
wonderful. I can hear
Okay.
you. Have
Can you can't see me, I don't think, even though
I
I've
can't
turned my
see
camera
you.
on. You can see me.
No, we can't see you. Have you got a presentation that you want to?
I do. Can I try and share it?
Yeah, please do. In the meantime, Elsje's got a hand up. Elsje?
Sorry, no, it's because I didn't know whether I was raising my thumb or my hand. Let me put my hand down.
No, that's all right. It's your hand. It's fine. Okay. Okay. We're waiting for Amanda to share.
I'm trying. It's thinking about it.
It's thinking about it. Okay.
Yeah. Share. Do you see anything?
No, not yet. It's still thinking.
You can't see me and you can't see my presentation.
No. Did you share and then go to share screen?
Share.
And then share screen.
Okay, it's got screen there.
Yeah. Okay, let's give it a moment. Something's happening. Nope.
You don't see anything.
Nope, don't. Not, it's all black.
Sorry, I'm going back.
Is your camera on?
It is actually.
At the top of the computer where the little eye is. You know that little thing, it's got a slide
Can
in
you
front
still
of it.
hear me? Because my computer is now on strike.
I can hear you very clearly.
Okay, jolly good. It wants me to join some other meeting that I don't want to join.
Okay, I can't help you with that.
It's software. Professor Jacqueline Heats is waiting for me, but now I'm thinking, how can I escape? So I'm sorry about this. I should have emailed you my presentation, maybe.
Well, you can still email it to me, and then what we can do is let Rosanna Denson do hers, and then we can do yours afterwards. Rosanna, are you available?
Yes, Marita, I am.
Okay, great. Have you got a presentation to share?
I do. I'm going to try to share it, but I have emailed it to you just in case I'm unable to do so. But let me just try on my side. Are you able to see my presentation?
Yes, yes, we are.
Okay.
If you can make it
Let
a
me
little
just go.
bit bigger, that'd be great.
Okay, let me just see.
You can make.
And now? Okay, let me just 1 minute.
I'm going to close there. There we go. Yeah, we can see. You can proceed. Thanks.
Okay, thank you so much, Marita. And thank you so much for inviting me to attend this colloquium and to present this paper. The title of my presentation is Maintenance Matters for Spouses Married by Muslim Rights. Now, I'd just like to go to the overview of what I'll be doing. So that's basically my overview. But by way of introduction, I think it's important to take cognizance of the fact that it's only since the Constitutional Court decision in 2022, which actually declared the Marriage Act and the Divorce Act as being unconstitutional, that Muslim marriages were actually granted some sort of legal recognition. If we look at the position prior to the enactment of the Constitution, we see that Muslim marriages and all the consequences thereof was largely unrecognized and unregulated. And it's only after the enactment of the Constitution that we actually had the ad hoc recognition of some of the consequences of Muslim marriages, but not Muslim marriages per se. And so the question now arises as to how can Islamic law be accommodated within the South African legal system? And in order to do this, I've actually looked at Islamic law, what that entails specifically as it relates to maintenance, and what the South African position is as well. So if you look at Islamic law, and this is taken from the major sources of Islamic law, which is the Quran, and the Sunnah, that is the actions of the Prophet Muhammad, peace be upon him. Well, we see that the duties of the husband would include the payment of dower, maintenance, provision of suitable accommodation, treating the wife with kindness, displaying equality where the husband has entered into a polygamous marriage. Now, I'm going to be focusing specifically on the aspect of maintenance. And we see that in terms of Islamic law, that the husband has the sole duty of support regardless of the private means of the wife. So this means that the husband has to provide maintenance to his wife in the form of providing her with food, clothing, housing, medical care, etc. And this is so despite the fact that the wife could be wealthy or own property in her own right, she's not under any obligation to contribute to the maintenance of the household. And we also see that where the wife does contribute financially, she may claim these amounts from her husband at a later stage or at any stage. And unlike South African law, we see that this debt which arises against her husband does not prescribe, unlike also the situation in South African law. Now, as far as the maintenance is concerned in terms of Islamic law, we see that this maintenance arises, or the husband's duty to maintain his wife arises as soon as the marriage has been solemnized. So this is irrespective of whether the wife is started living with him or not, for whatever reason. As soon as the marriage is solemnized, the husband has the duty to maintain his wife. Okay, now we see that in terms of South African law, that very, very different in that there is a reciprocal duty of support that exists between the spouses as soon as the marriage is solemnized. And this is so irrespective of the matrimonial property system that the parties choose to regulate the marriage. We also see that this reciprocal duty of support the parties have a reciprocal duty of support on a pro-rata basis according to the respective means, which is very different from the Islamic law position, which provides that, as I've said before, that the husband has a sole duty of support and the wife does not need to contribute. And where she does in fact contribute, she has a right to claim those amounts from the husband. We see that in terms of South African law, it's only where the spouses have specifically included this, the claim for if the one spouse contributes more than the pro rata share, that they can claim, but this has to be done in an antenuptial contract. And we also see that where the duty, in terms of South African law, where the duty to support is not fulfilled, the spouse claiming maintenance can enforce his duty.
Oops,
yes.
Sorry. We are missing your presentation. I don't know why. I don't know. It just says Eugene's document came up. Please just share again.
Okay, I'll just close it and share again.
That one we can
Okay, just 1 minute. Let me just open my document again. Can you see it now?
Oh, there we go. Yes. Yes, I can. Thanks.
Okay. So as I said, if the one party where this duty to support is not being fulfilled, the spouse claiming maintenance can enforce the duty of support by instituting a maintenance claim in either the High Court or the Maintenance Court. Now, if one looks at the differences between Islamic law and South African law, what normally happens if the husband having the sole duty of support towards his wife, if the husband fails in this duty, the wife would, in all probability, in practice, then approach maybe an imam or a learned scholar, or maybe the person who married them, and would lodge a complaint that the husband is not maintaining her, and he would then call in this errant husband and chastise him. But there was basically nothing that parties in reality were very reluctant to actually proceed to claim this maintenance in the maintenance court or even in the High Court. So they would approach religious scholars, and if the husband still, and the religious scholar would then rely on the God consciousness of the errant husband who's not supporting his wife and children, and chastise him accordingly. But if the husband refused to still make the payment, there was basically no legal enforcement where he could be forced to maintain his wife. Okay, so that's a position during the subsistence of the marriage. If we look at the position with regard after the dissolution of the marriage, where the marriage has been terminated by the death of one of the spouses, we see that the surviving spouse here is allowed to claim to be maintained from the estate of the husband for only a period of 4 months and 10 days after the husband has passed away. Now, this is during the Idat period, the period of mourning, and it's only during this period that the wife can lodge a claim for maintenance against the estate of a deceased spouse. This is in the chapter 2 of the Quran, verse 240. Surah Al-Baqarah provides the evidence with that allows the wife to claim, but only for that period of time. And there appears to be no exception to this rule. After consulting various authorities, etc., the claim for maintenance at the death of your spouse is limited to that period of 4 months and 10 days. Thereafter, the rules of inheritance takes place, where the wife is allowed to inherit in terms of the Islamic laws of inheritance, but no further claim for maintenance against the deceased spouse estate. So once again, very different in terms of South African law. We see that the spouse can lodge, once the marriage is terminated by the death of the one spouse, that the consortium omnis vitae and spousal maintenance comes to an end. So that is our general rule in terms of South African law. We have the exception that the surviving spouse can claim in terms of the Maintenance of Surviving Spouses Act against the estate of the spouse. Now we see that although we have court decisions which make allowances for the party, for Muslim parties, for the Maintenance of Surviving Spouses Act to be utilized by parties married in terms of Muslim rights. We see that this, in effect, although the courts have come to the assistance of Muslim couples or the surviving spouse in this particular case, we see that this position is actually contrary to the principles of Islam. As far as maintenance is concerned, where the marriage is dissolved by divorce, we see that here the husband, as far as maintenance is concerned, is obligated to maintain his wife for a period of 3 months after the divorce has taken place. Okay, this is also known as the Idat period. And after the 3-month Idat period has lapsed, we see that the husband now ceases to be responsible for the maintenance of his ex-wife, because they're now regarded as being legal strangers to each other. This is in the case of a revocable divorce. The reasoning being that if the divorce is revocable, the spouses reconcile and the marriage can still proceed. But after that, if the divorce is irrevocable, they would be regarded as the wife would cease to be able to be maintained by her ex-husband. Now, despite the fact that we have this provision stating that the wife is entitled to maintenance 3 months after a revocable divorce has been given by the husband, we see that there are exceptions to this rule. In the case where the wife is, for example, pregnant at the time that the divorce is issued. And in this particular case, the husband is then obligated to maintain the wife until the birth of the child. Thereafter, his duty for maintaining her lapses and comes to an end. However, if the wife is breastfeeding the child, the husband would also be responsible now for child rearing services, and you'd have to pay the wife for breastfeeding the child. If the wife is looking after the child, because that is also one of his sole responsibilities, which I haven't included in this discussion. But we see that the husband also has to pay his wife for looking after the children. Now, we see that at this time where the wife, where the divorce does go through and the husband then after the 3-month period has lapsed, the wife then once again becomes the responsibility of her relatives. If she has a father, it would be a father, a son, etc. Okay, and we found that this, in some instances, this can be problematic, because what if the woman doesn't have any parents, she doesn't have male relatives, or she does have relatives, but they are not in a financial position to support her? The next bit would be for the woman to apply for maintenance from the Baitul Mal, which is like a public treasury. As Muslims, each one is, you have to pay a tax, which is 2.5% of your salary, or whatever excess profits you have, etc. And this money, this tax is then paid to this public treasury known as a Baitul Mal, and it's distributed amongst people, the indigent, etc. Now, in South Africa, where we don't have, that works quite well in Muslim countries, but we're living in a country which is not a Muslim country, such as South Africa, this can be problematic. Okay, we also see that at the time of the divorce, the wife is entitled to any unpaid maintenance due to her that accumulated during the course of the marriage. And as we said before, that this is a debt that does not prescribe, and she can then claim this unpaid or arrear maintenance from the estate of the husband, ex-husband. Father is also, as I've also already alluded to, responsible for maintaining his children, and he also has to bear the costs of childcare. Okay, now the position in terms of South African law is very different, in that we see that if the parties enter into a settlement agreement in terms of Section 7, subsection 1 of the Divorce Act, or if they can't come to an agreement, then the court will make an order for maintenance in terms of Section 7, subsection 2. Okay, if we look at the, if we draw a comparison, okay, and we see that even with post maintenance differs markedly from that of Islamic post maintenance, differs markedly from that of South African law. We see that that the duty of support in terms of Islamic law terminates after the 3-month period has lapsed, and in terms of South African law, parties can still claim in terms of the maintenance of in terms of the Maintenance Act post maintenance. We see that, for example, that although the courts, South African courts have initially allowed lifelong maintenance, there's been a move now to rehabilitative maintenance, where the parties would only be maintained for a specific period of time. So when one looks at maintenance in terms of Islamic law as well as South African law, we see that they are markedly different, and one wonders how Islamic law can indeed be accommodated in terms of the South African legal system. So as for me, we were left with, because on the one hand, we see that women, especially women and children, they are the ones enduring all these hardships, trials and tribulations. So you'd want to, as a practicing Muslim, you'd want to conform to the principles of your religion, but on the other hand, you also have the situation where there are, in reality, these are the hardships that people, that women and children especially, which they face. So when one looks at, so those are all the differences which are now discussed, and one wonders how could possibly be reconciled how Islamic law can be reconciled so that it does fit in, or it can be accommodated by the South African legal system. The one common ground that I have earmarked is that of mediation, where because in terms of Islamic law, we see that if a dispute arises, and especially if there's a marital or family dispute that arises, we see that Islamic law makes it compulsory on parties to submit themselves to mediation. If one looks at Surah Al-Nisa, which is chapter 4, verse 35, there the particular what's called an ayat of the Quran of that particular chapter or verse of that particular chapter alludes to arbitration. But on closer inspection and closer investigation, we find that what is actually meant is that the parties it's compulsory for the parties to submit themselves to mediation before, if it's, for example, a marital issue, before they can get divorced. And we see that Islamic mediation is a well-established process for resolving disagreements. And the definition of Islamic mediation falls very much in line with what the definition of mediation is elsewhere. Okay, having gone through the maintenance bill, we see that mediation, if it is going to be included in the maintenance bill, because at this point in time, the Maintenance Act does not make provision for mediation as a process of resolving a dispute, but that it is clear that mediation has become a preferred method of resolving family disputes, which obviously includes maintenance matters. So if you look at the Islamic mediation process, we see that what normally happens is that if there is a dispute, the parties will normally, the husband, if it's a married couple, the husband will then get a representative from his family to, and the wife will do the same, 1 or 2 representatives, and then they will go to an imam who is either the person who married them or some religious scholar within the community, and that imam will then try to mediate the matter, the dispute between those parties. I have been on occasion called to mediate matters where the imam has felt that, look, he is not within his area of expertise, and I have been called on to mediate. So it does actually take practice in real life as well. We also see that the publication of the court and mediation rules on the Magistrates Court also is indicative of the fact that mediation should be used, going towards that direction, that mediation could be used as a dispute resolving mechanism. So we see that in terms of South African law as well, there is now a big move towards mediation, and not just in maintenance matters. I am a court and mediator as well, and we started at the new law courts in Port Elizabeth. There's been a project, a pilot that has been started, and for about 18 months to 2 years, I mediated on a pro bono basis for matters referred to from the Magistrates Court.
You have a minute left.
In conclusion, I'd like to state that the comparison between Islamic law and the South African legal system demonstrate that, whilst there are some underlying principles that are similar, the rules and principles in Islamic law are clearly fundamentally different from that of South African law. And that's why I posed the question arises whether Islamic law can indeed be accommodated. And we see that even though the courts have in the past been prepared to come to the assistance of couples married in terms of Muslim rights, the decisions of the courts has not always been Sharia compliant. That's my at the end of my presentation. Thank you very much.
Thank you very much. Yeah, there we go. Thank you very much, Rosanna. But always very interesting listening to you. Okay, and we have somebody on the other side. Amanda, I can see you. That's rather a great.
I'm using my iPad now. Thank you so
Okay.
much for this opportunity, and I'm sorry about all my troubles. But now on my iPad, it's got this thing that says share PowerPoint. Should we try that?
We can try that. I can't see anything yet.
Okay, it's got an error. So I'm going to try and share screen. But I sent it to you now on.
You did send it to me. Let me see if I can maybe share it from my side. Share screen. There we go. No, you're seeing all my emails, which is probably not a good thing. No.
Okay, that's your emails, and I'm trying to find my.
No, that's fine. Just hold on a sec. There we go.
Okay,
Got it.
thank you so much. That's the first slide. So I'm so grateful for this opportunity. I was reading this case, EWVVH, which is going to be a very important case, I think. But the case that is reported, can you hear me? Hello?
Hello, yes, we can hear you. We can
Yes.
see you. So
The
please
case that is
proceed.
reported is the application for interim maintenance and costs of suit. And it was denied. And it seemed to me that it was unfair, but there were a whole lot of procedural matters involved. And there was the suggestion that application proceedings were the incorrect way of going about resolving some of the issues. So that got me quite interested in what you can do with the claim for Rule 43, which you see on the screen, which of course is only available to married people. So if we can just stop on the screen for a while. Sorry, can we go back to the second slide? Thank you. So if the parties had been married, EW would have been able to bring a claim under Rule 43, and she would have obviously been bringing a divorce claim for the maintenance under Section 7.2. So this particular remedy was not available to her because she was not married. But one of the interesting things about the case is she decided not to challenge the legislation. She didn't challenge Rule 43 and she didn't challenge the Divorce Act. It was a deliberate decision, apparently, to only challenge the common law. Even, so if we can go to the next slide, even though this Rule 43 relief for interim maintenance and cost of suit is only available to married people, it's a codification of the common law. So in a recent High Court case in Cape Town, the person was challenging Rule 43, and the court said, well, you know, even if we ignore the remedy in Rule 43, there was still this common law claim. So I was quite interested in exploring how the common law claim worked, and seeing whether there was any way of using this to bring the claim of the litigant EW as an application. I think she could have done more, but there are reasons why it wouldn't have worked, but she didn't try this route. So this remedy for interim maintenance is very important. So here we have 1948, Spiro writing in the South African Law Journal, and he says today there's a certain degree of inequality between husbands and wives. So, you know, and then he says, since long ago, the law has tried to intervene and help an indigent wife to bring her claim to court, and in this case by providing costs of suit. So next slide. 71 years later, in 2019, the Constitutional Court is still insisting that this remedy is crucially important, recognizing that during the litigation process, many women, wives and mothers, are in financial distress and they need the interim maintenance and also the costs of suit so they can bring their claim. So next slide. So one of the reasons this is so important is that divorce proceedings can be protracted. And we've seen so many examples of this in the case law. It's just been dragged on and on and on. I mean, the Bannatyne case is a classic example of a maintenance suit, but nevertheless, you can drag out your suit and the spouse who is economically weaker can't last that long. So that is the reason for giving the interim maintenance and also the cost of suits, because it won't be financially, it will have a financial cost if you drag out the litigation. So these are the important things of the remedy. Now at common law, these suits were available mostly to wives. It was usually women who asked for this, but it was very much based on the reciprocal duty of spousal support that arises during marriage. Okay, next slide. So requirements for the claim were that you had to prove the existence of a support duty because it's based on the support duty. And the second thing that historically you had to also show was that you had a reasonable prospect of success in the main matter, the matrimonial suit that you were bringing. So those were the two requirements. So in terms of proving the existence of a support duty, for all support duties, you have to prove need and means. That's obvious. But in the case of this particular claim, because it's based on the spousal duty of reciprocal support, you have to prove that there's a legal relationship that gives rise to the duty, that would be the marriage. But until the no-fault divorce, you could lose your claim. There would be no support duty anymore because you were the wife at fault. That was sort of dispensed with after 1979 and the no-fault divorce. So you had to prove the existence of the support duty, mainly needs and means. But you also had to prove a reasonable prospect of success in the main matter. Next slide. So what did that mean, reasonable prospect of success? So I've been looking through Harlow from the 1st edition to the 5th edition, and he has more or less the same footnote every time. He says that he's reviewed a lot of cases, and more than 50 are listed there. And he says here, this is just for your information because it's difficult to discern a clear precedent because it always depends on the facts of that particular case. But as an overall thing, it's very rare that a bona fide application would be refused because the courts do not wish to deprive the wife of an opportunity to place her case before the court. So that's why. And mostly what she has to prove is a prima facie case that if her allegations were proved, they would give rise to a claim, and this must not be too remote. So where does that leave EW in her claim for a maintenance pendente lite and costs of suit? Because she's not married. So let's see what she could do. Next slide. Okay, so here are the facts of that case. It's a sort of classic case. The parties had been in a relationship for about 9 years. There was some dispute. There was a marriage initially as well. But for much of that time, they shared a residence. They had 3 children together. It was clear that they had a very high standard of living and that throughout this relationship, VH, the man, had supported EW, the mother, very generously, and the children. She is very much a dependent wife or partner. She didn't work, she had no, etc., and also no earning potential. So she absolutely conforms to the poor independent wife that Judge Moseneke talks about in the Gomedi case, that Justices Magoro and O'Regan talk about in Folks. She is very much that woman. Then in 2022, they break up. It was her idea. He moves out and leaves her in the lurch. So what can she do? She has brought 2 cases. The first is an action in 25th July 2022, but the case that's reported here is the application from the 27th of October 2022. So the court is having some difficulty with, I mean, it's very typical for the main divorce to be instituted as an action and then for an application for Rule 48 to be in the same court as an application running in a way concurrently. So that's what she has done. And her main claim is this. We know what Boanya did. It has provided a long-term life partner with a claim for maintenance under the Maintenance of Surviving Spouses Act, if the partner has died. But there is, in this case, it's based on the assumption that there's no claim for a person in that situation, like EW, where the partner is not dead, but she's more like a wife claiming a divorce claim, a divorce remedy under Section 7.2. So there doesn't seem at this time to be that claim for post-breakup maintenance for partners. So she's launched that action, but she's in the same time, she's bringing this application for the maintenance. Okay, next slide. Okay, this is the action. She says she wants an order declaring that they were partners. So she wants that declaration that they were in a permanent opposite sex life partnership and they had undertaken reciprocal duties of support. But she also wants an order that the defendant must maintain her for 10 years, and she's got a whole lot of factors that she lists. which are in fact copied and pasted out of Section 7.2 of the Divorce Act, but she says that was just convenient. And I mean, there are exactly the kinds of factors that a court would consider when making a maintenance claim. And then she says, if the law doesn't yet provide for this, the court must develop the common law. She's not challenging the Divorce Act, the common law to recognize this claim. So next slide. She's going to base it on the Constitution, basically. And I mean, obviously, the constitutional claim will be similar to what we saw in Boanya. And the case yesterday, or the day before, the EB case in the Constitutional Court, just talking about how we have indirect discrimination on the grounds of sex or gender, where the law is, you know, supposedly neutral. Nobody gets this maintenance, but it will have an impact, particularly on women, because they have assumed female gender roles. So, and then she wants the law to be developed, and then she also wants to bring the claim. So that's her action. Okay, next slide. VW, the defendant, resists that claim. His argument is they were not in a permanent life partnership and they had not undertaken reciprocal support duties. So that's just his allegation. So that's still pending. Okay, next slide. Meanwhile, she brings the application. She actually can't bring it in terms of Rule 43 because it only applies to marital proceedings. Now, she doesn't challenge that. She also doesn't challenge the old common law, which also applied to marital proceedings. So she hasn't directly challenged any of that there is no claim like this for interim maintenance. She's just proceeds. And that doesn't really come up. But carry on. The problem for her, I think she can show, definitely she can show she has the needs and he has the means, although there was some argument about that. But it's quite clear that those were the facts. That she needed the support. But just like wives had to prove that they weren't at fault in the old common law days, we can ask whether there is in fact a legal relationship that grounds this support, which I think there is. I'll explain why. But the second thing she needs to do is show a reasonable prospect of success with her primary action. And it's difficult to know how she's going to do that, where there is no claim of that kind at this time. So in her application, she tries to create that claim. She's asking the court now, as part of her application proceedings, to develop the common law to recognize and claim for ongoing maintenance for life partners. So carry on. The court says no, we are not in a position to develop the common law. One of the things that says confusingly is that she already has a claim, which she does not, but she has a claim, I think, for maintenance during the subsistence of the relationship, but not for post-relationship maintenance. But it says that we don't have enough information to develop the common law. It's a very big deal. The Minister of Justice should be here joined as a party in the claim. So we're not in a position, we haven't got enough information, and not everyone's here that should be. The other thing the majority says is also she doesn't need the support. She had used the word destitute in her pleadings, and the majority says you're not destitute because you can borrow all this money from your dad and all these sorts of things. And there's also a lot of child maintenance. So when I was looking at this, I mean, the child maintenance was part of that story, why she wasn't destitute. So I was thinking that outcome was not fair, and thinking that we should go back to the basic principles. So those basic principles at common law, you had to show that they were based on the spousal support duty, and it was very important, which always has been very important since the last century, 2 centuries ago, since the 1800s, and the Constitutional Court has emphasized recently how crucial it is. Okay, next, so go back to these basic principles and think what's happened here. Next slide. So we know they definitely, both the claims, the maintenance claim and the costs, were based on the reciprocal duty of spousal support. So next slide. So Boanya, to me, this paragraph 71 does so much just because of the wording. It can no longer be fitting to distinguish these 2 forms of the duty of support, the one that arises from marriage and the one that arises in the context of a life partnership, just because one is operational ex lege in terms of the law of marriage and the other one is based on an agreement. And then the court goes on to say that treating people in those two categories differently would be unfair discrimination, which ultimately the court puts at gender discrimination. So the wording that comes out of here that is used in the EW case by both the majority and the minority is that this is what they say comes out of Boigny, paragraph 71. A duty of reciprocal support arises between unmarried life partners who have undertaken reciprocal support duties in a familial setting. Next slide. So when you go back to the common law requirements, that the things you have to prove, that there is a support duty and that there's a reasonable prospect of success. Next slide. The minority held that this need and means part of the support duty, the support claim had been sufficiently shown. I don't know why the majority was in doubt, because there was a lot of evidence before the court, and also the minority referred to a previous case that had been held in George about the children. So I think that had been proved. The problem, of course, was this legal relationship giving rise to the duty. Next slide, which the court actually in EW has decided you can show this legal relationship if the life partners have undertaken a reciprocal support duty in the context of a familial relationship. Next slide. So there's a majority recognizing that would create a duty of support during the existence of the life partnership. And what the court said, what the majority says is she hasn't provided the facts to establish this, which I can't believe because there was so much information before the court. And because of Peshawar and Boigny, this duty of support will exist on the basis of a reciprocal undertaking in a familial setting. So if she could prove it on the facts, that duty of support would exist during the relationship. The minority has something similar to say. Okay, next slide. So this word undertaken, like what does it mean? I think it does mean a contractual undertaking of some kind, but it would normally be inferred from the party's conduct. There would be a tacit contract inferred. And the courts have been previous slide, sorry, but let's go back to this one, have been very willing to infer this contract. It's what happened in Peshawar, it's what happened in Boigny. So I don't really think this word undertaken is a problem. I think if parties do in fact support each other for a reasonable period, the court will regard that as an undertaking. And in fact, in the pleadings that EW put forward for her action and her application, I think she has in the alternative undertaken or in fact did it. She put both in there, but I don't really think it makes a difference. Okay, next slide. What is a familial relationship? You'll know it when you see it. But if you just take the national coalition factors, for example, these are the sorts of things. And all of these factors have in fact been satisfied in EW. They lived together for a long time and everyone thought they were married. So often the courts have referred to how did other people perceive the relationship. And, so that was obviously a familial relationship. So I think this part of the requirements, this duty of support was proved. Carry on. Next slide. Okay, so I think those things are satisfied. So next slide, what about this reasonable prospect of success? So Harlow has said that you sort of do need a cause of action, that the courts have been very open-minded because basically they want to give her an opportunity to put her case before the court. But I think the problem in EW is it's not clear whether she even has a cause of action because there's no claim of that kind yet in the law. That's why she thinks it needs to be developed. But on the other hand, I don't think it's remote. So the minority judgment, let's just go to the minority judgment, has emphasized the importance of providing her with an opportunity to bring the action. And it has noted particularly all these things that come out of Boigny, for example, and the more recent case, that the EB case that's just been in the Concord yet the other day, that we have relationship-induced dependence, that the Constitution requires us to ensure substantive equality. So this is always a thing about maintenance, that it is very, very gendered, and denial of maintenance is very gendered. So on this basis, I don't think her ask was too fanciful or a negligible suit. That's what Harlow also uses, that word negligible, fanciful, too remote. I don't think it was remote, that she would be asking for the consideration of this as a possible claim based on the common law and based on the Constitution. So that's my argument. So I've sort of flown over it. Thank you.
Thank you very much, Amanda. Appreciate it. Ladies and gentlemen, we are running a bit late. So what I'm going to do is we're going to break for lunch now. And so that we can, would 20 minutes be sufficient for lunch? And then we can start at 1 and then we're back on track. Okay, great. We'll see you at 1 o'clock. Thanks very much again, Amanda. get a 2-line bio. She's an expert in family and child issues, which Elsje, of course, you are. And I always say, if I grow up, I want to be like you, because really what you write is always very insightful. So thank you very much. And this is also the start of part 4 of our program, which deals with a practical enforcement, which is clearly, as we've seen, a huge problem. And Elsje will be speaking to, well, I think what is key, getting accurate financial information. So Elsje, over to you.
Thank you, Marita, and thank you for inviting me. And my bio is not short because I'm great, it's because I'm lazy. So let's not forget that. So and I must apologize, this was a bit of short notice. So my first idea was I was going to be the third person who was going to speak on cohabitation and duties of support, in a third in line from what Bridget was doing. But I'm very happy that Bridget got to do it rather than me, because her pictures of the funeral parlor were so inspiring. But so what I first thought of doing that, but then I thought I must do something a little bit more practical. And I usually go more for the theoretical side of things, but then a relative of mine had to deal with a child maintenance issue, and her experience was as grim as Carmel's experience and the other experiences that we were talking about this morning. Her experiences with the court system were really very unpleasant, and I thought I'd rather do this thing, which is a little bit exploratory and a little bit sketchy, but kind of it's more throwing ideas out rather than presenting a full and proper paper. So this is what my relative said to me as she ran out of money to participate further in the court process. And she was told by her attorney that verifying her ex-husband's claim that he had no money, which everybody knows he does have money, would cost the earth, because it would require the appointment of a forensic investigator or something. And the people at the maintenance court were also very unhelpful. So I'm kind of thinking about ways in which we could consider how to rebalance the system a little bit in favor of the person needing maintenance. And as you all earlier said, that this is a gender issue, because very often the person needing maintenance, or more often than not, the person needing maintenance is the mother and the wife who has the responsibilities to look after the children, whilst the former husband or current husband or former partner usually has more money and he has more information about the family finances. So I do think that this is a gender issue. And when we are dealing with maintenance, what is supposed to be a relatively simple mathematical exercise for which one could even have a formula, becomes very time-consuming and expensive, because it's very difficult to get the information about your ex-partner's financial position from him. It becomes a very time-consuming and a very expensive opportunity, and it becomes kind of a situation of silly ploys of revenge and one-upmanship, and hiding assets becomes a game of hide and seek. And as previous presenters indicated, the lack of information and the preventing the other party from getting information becomes a means of starving them out. They are in court because they need the maintenance. So they are the vulnerable parties who are claiming the maintenance, and hiding the assets is one way of basically kind of starving them out of the litigation. So I was looking at the two papers that are available currently in the Law Reform Commission on family law related matters. And the one is the discussion paper on maintenance, which we've been talking about. And then there's another one where we've just had a discussion paper on a review of matrimonial property law. And I am part of the matrimonial property law advisory panel, and I must tell you that I've been on this for the past 20 years, but I'm hoping that we may make some progress and do some things. But in any event, the thing about these two discussion papers and the situations that they are looking at, I think the common thread is the importance of accurate and reliable information about both spouses' financial positions, because the calculations of them in and of themselves are really not so difficult. And if we as lawyers can't do it, well, we can get an accountant or an actuary or somebody to do this for us. But in both situations, the lack of accurate information is a problem, which kind of draws out the litigation and in the end really works to the disadvantage of the more financially vulnerable spouse, who's usually the woman. So I thought maybe we could compare situations and maybe we could learn the one from the other. And this is, as I said, it's a bit of a kind of a starting point. So if anybody wants to collaborate and help me write this thing, we can. I'm happy to talk about it. So in the maintenance investigation, it seems that the recognition is there that there are mechanisms which are helpful to get accurate financial information, but that they are not really working. And Leentjie has been telling us about regulations 2 and 3 around the provision of financial information. I didn't know about that, so thank you, Leentjie. That's very useful. Let's see if we can, if perhaps looking at the matrimonial property one might help us a little bit, because unlike in maintenance, where the Maintenance Act does have existing provisions which aim to help get accurate financial information, or at least the maintenance investigators should be able to assist there. There is really very limited provisions relating to accurate financial information in relation to matrimonial property. The Matrimonial Property Project suggests the creation of statutory duties to disclose certain information at 2 stages of the marriage. If we think of the marriage as the kind of coming together and separating, then again the assets of the parties. So there are 2 stages at which the suggestion is that there should be a statutory duty on both spouses accurately and fully to disclose financial information. The first is that there should be financial information provided before people enter into an antenuptial contract to ensure that their agreements are based on accurate information and are done on a basis or are negotiated on a fair and equal footing. At divorce, that's the first set of disclosure provisions, and there are also provisions there relating to separate legal representation when the parties enter into an antenuptial contract. And that's something that one could possibly think about, kind of whether this could be useful in the context of maintenance when settlement agreements are made about maintenance. The second stage at which we suggested that there should be a duty to disclose is at divorce, that the parties should have a statutory duty to disclose certain information at divorce in order to expedite the proceedings, in order for courts to make a fair and accurate division of properties, and in order to help the parties bargain on a more equal footing. And in the case of both of these duties to provide information, the suggestion was that they should be duties of the utmost good faith, duties iberi mai fidei, as we knew it in the olden days. And one of the things that I think I would like to explore is, what does it mean for a duty to provide information to be a duty iberi mai fidei, and on what basis will you then categorize this relationship as a relationship, Ibrahim Fidei, perhaps whether you could base this on the best interests of the child or what you could do. And then if it is indeed a duty, Ibrahim Fidei, I would like to explore the consequences of what happens if you do not accurately and fully disclose, as we know many people do. So the matrimonial property project provides very specific suggestions about which categories of information must be disclosed, and they could also be useful in the maintenance context, and I list them there, particularly basically all financial information, but including information around pensions, and which pensions and annuities, which Clement will talk about later this afternoon, and trusts, family trusts also. So there's a list of information that needs to be provided, which could be a useful thing to draw up. Unlike the Maintenance Act provisions, the Matrimonial Property Project places the duty to disclose on the parties before the court proceedings. So it's not part of the court proceedings and nobody's going to help them. There's no maintenance investigator, but they should have a duty to disclose before the court proceedings. And we based this kind of remedy on the example of duties to disclose in Rule 43 proceedings. So there's a Harting case called E versus E, 2019 5 SA 566 Harting, Johannesburg. In the full bench of the Harting division recommended that in order to expedite Rule 43 procedures, practice directive should be adopted in the division for the compulsory completion and filling of a financial disclosure form, setting out the parties' financial circumstances, including every class and type of assets that they might have before the litigation, before they appear in court. So how are we then suggesting that this information be provided in the case of divorce? There were two options. The one is that a party will be able to bring an application for the disclosure of information, but that means that people have to go to court again, and the lawyers are laughing all the way to the bank. So that is not really helpful. So we suggested that the summons, the divorce summons, must contain a prescribed list with the kinds of financial information which both parties must disclose within a certain time period. Maybe this is something that one could consider that might be useful in the maintenance context. There are two specific things that I want to just kind of note about two similarities between the maintenance and the matrimonial property discussion papers. Both consider it necessary to add explicit provisions that the veil of the trust instrument may be pierced in certain circumstances, and that trust assets may be used to satisfy claims for maintenance and claims also for marital assets to be distributed. However, the problem about trusts seems to me, if I look at the case law, is that it's very difficult for usually wives to get information about the trusts, because the typical situation is that the husband would set up the trust, or together with family members or whoever, and that he would have exclusive information about what's in the trust. And once she either summons him for divorce or he decides to get divorced, well, that information is really very easy to hide. So we have made a list of information in the matrimonial property discussion paper, listing specific information which must be disclosed. They relate to the trust instruments, but also to the trust bank statements. And they would make it easier then to make the argument, or for a court to see whether the trust is in fact just an alter ego and is being used to hide assets from the other spouse. The other thing that the two discussion papers also have in common is that they both consider it necessary to add explicit provisions which aim to make payments from annuities available to satisfy maintenance debts and assets distributions. But as in the case of trusts, information about annuities may also be very difficult to obtain. And we know that spouses deliberately move money into annuities from pension funds to put this money out of reach of their spouses, because the annuity is not regarded technically as an asset in the estate of an individual spouse. So in addition to declaring that that money from annuities should be considered in distributing the assets at the end of a marriage, the Matrimonial Property Commission discussion paper places an additional duty to disclose certain information regarding annuities and pensions in the Matrimonial Property Act, which might also come in useful for maintenance. But then I'm speculating about other wild ideas about where would one get information from. And I must agree with Carmel's experience and Carmel's idea that SARS seems to be the most efficiently functioning government institution at the moment, and that why can there not be legislation requiring SARS to provide certain limited information? You don't have to say, for instance, what his income is for this, that, and the other, but to get this information from SARS, for SARS to say, look, we're taxing him on X amount every year. That could be a possibility, because they would have this information. There is also once you kind of think around SARS, there is also the possibility of using the fiscus to distribute maintenance, and that's been mooted many years ago, and I don't know why we haven't come around to it. I do think that's a good idea. Also, to create specific statutory duties on financial institutions like pension funds and so on, to provide information for them to be notified as soon as a divorce summons is issued, to be notified and requested to give certain information to the court, and thus to the parties. And then I was wondering about state-appointed forensic investigators, which I suppose the maintenance investigators are to some extent, but maybe they're just not enough of them. Yeah, so these are my wild ideas, and if anybody's interested in working with me on this, I think I should try to turn my hand to something slightly more practical than kind of vague theoretical speculation, as I usually do. Thank you. I'm going to stop sharing. Marita, have I stopped sharing, or am I still sharing? I can't hear you.
I think you're still sharing.
Oh, well, on my side it says I'm not sharing, right?
We can still see it though.
Well, can't you just, I don't know.
I'm not sure if they can hear us now.
I think there's a little bit of a loose wire in my mic. No, you are still sharing, so it'd be great if you can maybe stop sharing. That's great.
Hide share. No. Stop.
And then what I'm going to do is I'm going to see if I can share from my side. There we go. I got it right. Is Judge Tulare, are you available? Can you hear me?
Yes, I am. I can hear you properly. Thank you.
Welcome. You've been very quiet. It's so nice to have one of the justices with us. Just for your information, the judge is also doing his doctorate at the moment at the University of Western Cape under Julia Sloth-Nielsen. He's a very brave man. But you have the floor. Your 20 minutes starts now. Thank you.
Thank you, and good afternoon to colleagues. Perhaps just to indicate that I took this opportunity to join the discussion, just to share what I'm writing on in respect of the thesis that you're referring to. And what appears on the screen is basically the title of my research. Maybe when we move on to the next script, just to indicate the background and what informed this. I am a practitioner through and through. Just like Mr. Opperman, I've the better part of my life I've been in the trenches on the ground with maintenance recovery, and one has an idea of exactly what is happening in practice, and perhaps to use that information to help guide the prescripts that guides maintenance recovery. But what one observes as a point of departure is the absence of the involvement of maintenance officers in civil execution to guide complainants. And this is not only in respect of the execution of an order. The problem starts even at the beginning when you enter a maintenance court to apply. The biggest challenge is that at most times, the person that you're dealing with is a clerk of the court, generally functionally illiterate to engage with the matter, so serious as requiring the attention sometimes of experts in the social network that we are trying to get of the welfare of the children in particular. So the Act as it stands, when one carefully reads it, it doesn't set out the role that a maintenance officer should be playing, which is very central. There is a problem, and that problem centrally is the maintenance officer at a maintenance court, because this should be a legally trained person who receives an application, whether it's a substantive application or an application to civilly execute, who would study it and then make a determination of what course of action is being taken. But as I said, that decision is normally taken by clerks of the courts. And in other stations where there is no maintenance officer appointed by the Department of Justice, those decisions are normally taken by public prosecutors. And that's also part of the problem, because as you may recall, currently it depends on who's the National Director of Public Prosecutions as to the role that the public prosecutors actually play and want to play in the maintenance recovery. Some of the NDPPs come in and withdraw public prosecutors from maintenance recovery unless it is a criminal enforcement. So the whole application itself, members of the public struggle with clerks of the courts to get those matters, and those clerks of the courts do not have the right of appearance before a magistrate, with the result that there is a problem at that level. So one of the things that stands out is the need for the department to appoint maintenance officers, legally trained persons who one assumes would have some functional literacy in civil law and our civil procedures and would assist. Because going on to the future maintenance, the greatest challenge that one sits with is the challenge of dissipation of funds. What happens when a person against whom an order is made or is intended to be made is willingly dissipating those funds? Those kinds of applications to succeed before a court needs, in my view, a legally trained mind to argue them. And that's the problem. And currently, on the Act as it stands, there is no provision for future maintenance, and that is why the decision by the Commission in its recommendations for provisions speaking to maintenance, future maintenance applications, both in the Act and the regulations, very welcome. So there is no legal infrastructure currently for future maintenance recovery. And this led to some of the people taking these matters to courts, and this led to courts making some pronouncements. And in my second slide, I'm discussing some of the leading cases there. The case of Mugadi, this is where the court indicated that you can use a civil remedy of an anti-dissipation order to recover maintenance on from a respondent who's clearly dissipating those funds. Mageu, where the decision was there need not be arrears at the time that the order is made, as long as there is demonstration of a hostile mindset and a history of non-payment of maintenance, that this intervention may be necessary. Beggar, where a person was not eager to work but had money stored somewhere, that those monies could be used. Solar and the maintenance court in Weinberg. And this case, for me, it's important for the conclusion that the court arrived at in giving guidance, especially to magistrates courts, to say, whereas ordinarily when you sit in the district court, you do not have certain powers and you cannot make certain remedies available to parties. But when it comes to maintenance matters, you see it as a sui generis, as a special court that must ensure that remedies, even those that are not very clear from the Act, are actually available for parties. And then going on to the next slide, one of the other challenges that goes hand in hand with the ordinary substantive maintenance application, but also with future maintenance applications, is how do you quantify the amount? Throughout the history, there hasn't been guidelines to assist, and that is why some of the decisions are haphazard. Sometimes you expect a certain order, and then you get another one. Case law, there's no uniformity. Some of the judges have tried to help by introducing the ratio of 2:1. Magistrates have tried to create and be proactive by doing apportionment according to monthly income and adjustments and improvements of those methods, taking guidance, especially with regard to future maintenance from the regulations in the Estates Duties Act. And also, to do some kind of models and formulas to try to help, like taking the amount that is payable per month that has been determined, you multiply it by the number of months in a year, you multiply it by the age of majority of the child, less the age of the child, you put in a 10% built in for increment. All these are models and formulas and attempts that are created by judicial officers in their attempts to come to an award. But as things stands, there is no prescript on how you approach the question of the award. And that is why sometimes the gap between what is expected and what is in fact granted sometimes becomes very big. And in my fourth slide, dealing with the application itself, what is it? It's a form of an interdict, but it's special. It has got its own special features that are unique. It is a very technical application. Even legally trained minds, even here at the High Court level, sometimes struggle with interdicts, especially where some take the form of mandatory, some take the form of prohibitory, some take the form of being interim, and then some are final in nature. Those distinctions, and this comes to the fore not only in the relief that you're seeking, but also what you aver in your papers, in the application itself, and therefore in the need to comply with the prescripts in the magistrates' courts, because maintenance courts are seated in the magistrates' courts. Magistrates' courts are so-called creatures of statutes. Whether they are graduating into constitutional creatures, it's still debatable. But Section 4 and Section 5 of the Magistrates Act guides, as well as Rule 55, on how magistrates deal with applications. Now, the approach generally to maintenance matters is that processes must be less formal than they should do. How less formal do you go in these types of applications? And the nature of a future maintenance application makes it very clear that unless you are legally trained, it is difficult, if not impossible, to successfully place an application before the judicial officer. And that is why, for me, the centrality of the role of a maintenance officer who's legally trained and who's functionally literate in civil adjudication and civil processes is very necessary if we are to succeed in building up a maintenance recovery system that actually serves its purpose. And moving on to the fifth slide, I'm basically here sharing with colleagues, the research question on what I'm dealing with. How is future maintenance award for children determined and the award recovered? I think I've highlighted some of the challenges. What is the current legal practices regarding future maintenance for children and its recovery processes? For now, I think the first word is a nightmare, but then one goes on to set out what actually happens, because as I said, it's a very technical application. It needs a legally trained mind. Ordinarily, people who deal with these matters, sometimes even if you arrive at a magistrate's court, especially in smaller towns, you don't have a maintenance officer who specializes appointed by the department. You're left with a public prosecutor who has never done a single application in their lives. They studied at university. After completing, they joined the National Prosecuting Authority. All that they need, and they know best, it's reading a record, formulating the charges. So the moment you talk about a special application like a future maintenance application, it becomes a challenge. Is the procedure adequate to meet the best interests of children as things stands? That's what one intends researching. How would the propositions in the thesis contribute to a sensitive and fair approach to the determination? I have the benefit of practice, so I'm looking forward to breaking down and making my contribution in relation to specifically future maintenance recovery. And at 6, I'm sharing the methodology and also consideration of the prescripts and the books, the journals, and I'll also share how this thesis will differ from some of the propositions, some of them made by some of the esteemed colleagues that I've had occasion to listen to this morning. So hopefully I will make a contribution that will at least elicit a debate, if not help out. And in the last chapter outline on the last slide, I'm just basically setting out the 6 chapters and how I intend dealing with these issues. But the main focus would be, as I indicated in the introductory part, the determination and recovery of future maintenance, how the awards are made, the process of coming to court, ultimately the orders, and one hopes to make a contribution. Thank you, Prof.
very much, Judge McLaury. We're looking forward to reading your document eventually. I'm sure it will be, you will make a contribution. Ladies and gentlemen, this brings us to one of our in-person presenters, Ms. Motshabi from the Department of Justice and Constitutional Development. I feel sorry for her because she's heard a lot of interesting stuff today. So you didn't send me a, did you send me a PowerPoint? Okay, I'll, there we go. I'll put it up now.
Thank you, and afternoon. Before I start, maybe let me indicate I'm not alone. Like you said, Prof, a lot is all, missiles have been firing DOJ all the way. So I'm with some of my foot soldiers that when it's tough, I have to make them shield. I'm joking, but they are always there to make sure that we monitor with the intention of improving services of maintenance. It's Mr. Ntlemo is our maintenance officer from Garankuwa. And then I have my area court manager, Mr. Mpalo from Rustenburg. I have Advocate Takula and Advocate Afilika. These are my foot soldiers. Without them, I won't be able to survive. Okay. Thank you so much, Prof. Initially, when Prof invited me, we were supposed to talk about the challenges in the DOJ. And then I requested, because in my mind, I was like, if we just go to challenges of which most of the speakers have already touched on, because it's things that we know through our complaints sections, through our complaints management, you are able to pick them up. And on a daily basis, you are trying by all means to make sure that when we resolve, we don't just resolve for one case to be finalized, but you also strive to ensure that maybe the mistake doesn't happen. But when you deal with human beings, you deal with attitude, you deal with a lot of things. And but as management, together with Advocate Ilse Bezuidenhout, you just have to talk and make sure that people do their work at the end of the day. So you'll see my presentation. I'm trying to share what is it that in the DOJ, specifically focusing, especially when I talk about the human capacity, I'll be focusing on the province, just to give you an indication of what we are dealing with against the millions. Not as a defensive mode, but just for you to understand some of the challenges and the contributory factors. Oh, okay. Takula? My phone, I'll use the one on the phone. Thank you, Prof. And I must say, Advocate Bezuidenhout, Prof, in the Northwest, we are very lucky. You know, I had just talking about the, even Leentjie, Prof Leentjie touched on it, normally the confusion that that we normally encounter, which is created by that section 4 between the public prosecutors and our maintenance officers. Luckily here in the Northwest, I must say we have, because of the strong stakeholder relationship, the Advocate Smith, then DPP, issued a circular clarifying that doesn't mean when a maintenance officer is appointed in a particular court, it exempts the prosecutor. So I must say that luckily in the Northwest, we have that strong relationship, and we always engage, no matter how difficult it is. The reason why we had to sit in one table is because we were engaging about one of the cases. I think she will share with us, because we are seeking legal opinion on that case, and also we will, Mr. Ntlemo was handling the case. I'm trying to look for it in my. Just bear with me. Okay. While Prof is still struggling, I can continue. Let me use the one that is on my phone. As I have indicated, I was requested to talk about challenges, but then I took it upon myself to say, let us include, with the intention of just sharing with everyone here, what is it that we have and how we deal with maintenance, not sharing the process, but just to share so that you have a picture of what the DOJ is having and what is it trying to do in taking and ensuring that we improve the service delivery going forward. Slide number 1, I had included the difference of between the prosecutor as a maintenance officer and but I'm not going to deal with that because previous speakers have talked about it. And the intention for me to put it there was to brag about that circular that I was talking about, because wherever you go, there's a tussle between maintenance officers and the maintenance officers as to who does what. So I would like to share with you, focusing only on the Northwest.
Hello?
Thank you, Prof.
I'm going to share now.
All right. Okay, I can just proceed.
Okay, try now. Maybe lift it up, maybe it doesn't.
Oh, I think it's a cell phone. Eh? Yeah. No, I wanted to use it because she can't share. You'll share. So much. What I wanted to share with you is just about the few lines. It's just I wanted to indicate the number of maintenance officers that we have and the numbers of maintenance investigators that we have in the province. Currently in the province, we have about 32 courts, all in all, 32 magistrate courts. And having 32 magistrate courts, we are having about, is it 24? 24, I'm not good in numbers, I only know my money. 24 maintenance officers against 32 courts. And then we have about 22 maintenance investigators. Meaning other courts, they do not have maintenance officers. We're relying on prosecutors. The reason why I am sharing this information is sometimes that's where, and the judge also touched on it, because when people talk about DOJ, the complaints indicate one thing: the delay in finalizing cases, the delay in getting the money. Those are the two complaints that normally comes up. They are being brought up about different circumstances.
It is definitely.
It's a 2 devices. If you have 2 devices unmuted, you will have a feedback. Prof?
Okay, no problem at all. So I wanted to share with you because it will give a picture why in certain instances we have an indication, because I know Makira and we have challenges and we do not give the service the way it's intended to. This is not being shared as a defense, but it's just to show, to say, as much as the department is trying to improve, but there are certain factors that might contribute negatively towards that. So in the province, that is what we have. And all of our maintenance officers are legally qualified. There is no one who's not legally qualified. Appointment as delegated by the minister, we only appoint people who are legally qualified. Give up. Okay.
Anybody got a little stick for me?
I have it in my USB.
That'd be great. Thanks.
Yes.
Okay.
Okay. Because I had saved it, but then I sent it via email when I saw that you were connected, so that we can be able to.
I think I'm the best example of a little knowledge is dangerous.
But I'm definitely sure after this will be no. Yes, thank you so much.
Oh, yay.
Thank you so much, bro. I'm a BBC. Oh, you, okay. So you remove it from. Thank you so much.
Here you go. Can you all see that?
So we can move from this one. Yeah. Huh?
So that one.
Okay. As indicated, I wanted to introduce our mandate, but that has been discussed a lot. The Section 4 of the Maintenance Act has been explained by different speakers, so I'm not going to talk about it. And also the establishment of the maintenance courts and this particular slides, because I just put it there to share and to clear that confusion that we normally come across. Stakeholders thinking that when there's no maintenance officer, there's no one who handles a maintenance. And we know that sometimes our officials that report to us, they take that advantage. They would say no, because it happened in Posh. I think the attorneys in Posh will remember when Advocate Lakula left, it was like, there's no one there. And we were undated with calls to say, when are you appointing a maintenance officer? And myself and Advocate Ilse were saying, there's a prosecutor while we are filling the post. So it shouldn't be like that. But it's good that the attorneys and everybody was making sure that we are aware of what our officials are trying to do. Like I said, we have, in the Northwest regions, we have a 25 maintenance officer, of which 2 are vacant, and 23 maintenance investigators. Currently, the region has 10 courts without maintenance officers, and prosecutors in those courts are performing the duties of maintenance officers. And then we have clerks that Judge Tulare said something about them, I'm not going to repeat, that are assisting and supporting the maintenance officers. Maintenance officers to us as the DOJ, we see them as primary investigators, because and I think the judge also touched on it when he was saying the maintenance officer is missing from action, especially from the application. But We are regarding the maintenance officer as a primary investigator. Meaning, we are saying as soon as the clerk has completed the forms and everything, he has to hand over to the maintenance officer. And the maintenance officer will have to screen and make sure that go through the application. And whenever there's a need for him to engage now the maintenance investigator, then he will do that. Hence, we highlighted the fact that we see the maintenance officer as the primary investigator. Even the Act indicate that. Emo, I don't know if you, but you know that's how it should be. And and the maintenance investigators, they normally use the tracking tool to check the whereabouts of the respondent. But you'll see when I check, I get to the challenges. This tracking tool only works if you have proper documents. And the Northwest is in the rural. Like, let me give you an example of the village where I come from. The house numbers, they only have these numbers. It's not a proper address. So if a person doesn't have an ID number, if a person doesn't have the cell phone number, there's absolutely nothing that we can do about it. So those are the contributory factors towards us. Sometimes DOJ, it's like it's failing in ensuring that this act is properly implemented. But there are contributing factors to that. The applications that our maintenance officers are currently dealing with, I'm focusing on the Section 4.2 maintenance officers, who's the ones that are appointed by delegation of the minister. Child maintenance, spousal maintenance, reciprocal maintenance, and future maintenance, which the judge has talked a lot about it. This is where our main challenges are, future maintenance. Even when we were at the Indaba, where I saw Mr. Lori and Felicity, and at the Indaba, this was debated. We have a serious problem and we cannot run away from it. We just have to get the legislation so that at the end of the day, our maintenance officers are not being held accountable for somebody, because somebody has reported that my husband has resigned, and then the next thing, the money is being moved from to other banks. But I'm glad that the judge also touched on it. And we all know that a maintenance order may be granted by consent, default, and after formal inquiry. We have the norms and the standards. The norms and the standard in the DOJ, the intention is to, like I said, improve the services as on daily basis, let me put it that way. And I know most of the people do not agree with the standards of finalization of cases within from 90 days from the date of proper service. But this was informed by the rate of finalization before this norm standards. Take into account the challenges that we come across of services. We have a challenge of sometimes sheriffs will just give you a nulla bona, saying we can't find a respondent. And like I have indicated, in some courts, we don't have investigators because we use sheriff in most cases where we do not have investigators. But when they come and they give you a nulla bona, what do? You have to see how best you can deal with it. So the standard was informed by the challenges, but I can assure you, and the maintenance officers are here, most cases are finalized before the 90 days. Because most cases are finalized by either consent or by an informal inquiry. We have few complex cases, I must put that. I wanted to bring my stats for the Northwest that indicate just for the financial year, how many cases were outside 90 days. It was not a lot about that, but I'll share them with Prof. I'll just add a table so that he can share, and then but can update the presentation. So most of the people do not agree, and I understand why. The intention for somebody to file an application today and tomorrow they get the money if it was ideal. But we know it doesn't work like that. Hence, the department came with the 90 days from the date of proper service. We also have the complaints management system, and we are expected to resolve the complaints within 7 to 14 days, depending on the complexity of the matter. And also we have the financial system, and the intention is to pay the beneficiary 4 days from the time the department has received the money from either the respondent or the respondent's employer. The challenges that we normally come across that also contributes towards us maybe delaying or not giving the service that is expected from us. Submission of incorrect, insufficient information by complainants. In each and every court where you go, you'll find when you meet, before you can meet the clerk, there's a list of the documents that you are supposed to bring. It's indicated in there. But you'll find that a person, when we're saying incorrect, they would either, there was a case where we were furnished the maintenance court, the maintenance officer was given a photo. I like using that as an example. And we only came to realize at the end when public protector was even involved, because the public protector got involved because we were delaying in finalizing the matter, only to find that they are using a photo to trace the respondent. And I was like, a maintenance officer, you should have stood your ground to say, that that person even traveled from Mafike to Michelangelo Hotel in Sandton because there was somebody said they saw a chef who looked like that person. So when we got involved, the money for the department was used, people were traveling and everything. And we were like, public protector, we can't use the photo. Honestly speaking, sometimes we have to agree and say a photo can never be a document where you'll identify a respondent. But these are the things that we get from court, and we try to deal with them as we deal with public outreach. Insufficient information is what we talk about. People are not updating from their cell phones. The maintenance officer gets an address only to find that the respondent has moved 2 years back. So those are the challenges that we normally come across. And we have also unreasonable postponements by legal representative, enforcement of maintenance order in an informal business. Taxis, those that are doing business for themselves, we must say it's not easy to enforce, whether we like it or not, because they have a way of dodging the court order. As a result, the court order remains not being enforced. Non-regulation, I think Judge Tulare talked about it, of future maintenance, contradictory precedents from different high court decisions for enforcement of future maintenance, which has resulted in some pension funds reluctant to comply with future maintenance order. We have a case that we have referred to our Legal Services National Office. In Garankuwa, where it was dealt by Mr. Ntlemo. We have about 10 beneficiaries. The court orders have been issued. They only chose to pay areas. They are refusing to pay future maintenance. And there's a legal opinion that they are relying on it. So those are the things that when something is not regulated, everyone will do as they please. And at the end of the day, we all agree who suffers is the child who's supposed to get food. So one of the ways that we use to improve and to ensure service delivery to the public is that we encourage our maintenance officers to try and resolve cases at the early stage. And I must say, it helps, it happens, because most cases have been finalized at mediation, at an early stage where the maintenance officer mediates or through consent orders. Interim orders, in case there are postponements, maintenance officers currently are using that because before cases would be postponed. In the meantime, a poor mother doesn't know what to do. So the maintenance officers are using interim orders while the cases are being postponed. And this system assists us to finalize cases. We also have the ICMS, it's the Integrated Case Management System, This system, it helps in tracking down cases. The 90-day standard that I was talking about, this system is to monitor that 90 days. And we account for each and every case that is outside 90 days. Like I said, most people would not agree to say 90 days is too much because it's 3 months. But we were taking into account the challenges that or the challenges that we encounter as they implement and trying to finalize maintenance cases. I joined the department in the from 2013 as a director, and when I joined the department, the regional head instructed us that it was Mr. Makutle. All old orders were converted to direct maintenance. And I was humbled by the cooperation that we received from beneficiaries. They came, they opened bank accounts, and they were not receiving money now manually. Most, they are receiving money through the bank accounts. That also assisted us because we experienced a lot of fraud at that time because the money would lie around in court. But most of the maintenance officers of maintenance beneficiaries, they know when they come from the first application, they must have a bank account. And it works wonders for us because you are able to even pick up when the money is not deposited. They will call in my phone to say, I did not get money. We know that they are reporting that somebody has defaulted already. So in a way, it really helps. So Northwest, where it was one of those provinces where we converted all old orders to direct orders. Currently, we are only taking direct orders. We are encouraging them, even the informal, because the applicant would be having a bank account, even the informal, but they use the system that we call Motshabi. They still pay into our account, and we pay to the applicant because we don't want them to go and pay the applicant. So we still managing that to make sure that the children receive money. And the other thing that we want to do is we notice that there's no uniformity. So the practice directives, we would really assist, and we have to work with all stakeholders to ensure that we have practice directives that will ensure uniformity. For me, if there is uniformity, as much as we complain about training of maintenance officers, as much as we complain about the technical skills, we can make things easy if we have practice directives. They will be at least understanding that this is the process that I have to follow to make sure that Motshabi as an applicant comes today, in 3 months, the money, she received the money for the child. It's to also establish maintenance forums where we're also going to invite the maintenance beneficiaries, not all of them, but we have NGOs like Tabo Felicity that would come in. The intention is not for them to speak for us or to speak for the department or to agree with us. I believe in public education, and public education has to be done anywhere, everywhere. So when somebody understands not the legality of the maintenance process, the reason why I like using the photo example, when now somebody comes and understands, oh, this is how I contribute towards delaying a case, I think they will continue sharing and telling others to say, I was in court and I was advised to do 1, 2, 3. At first I thought I was right, but now I know that I also contributed towards the delay of my cases. That's how we educate the public. We don't have to just bring them under a tree and talk to them all the time. We need to find a way and innovative ways of sharing and making sure that they understand, especially what is needed from them. We will do the rest. So that's what we want to do with the maintenance forums. We will definitely make sure that we involve the maintenance beneficiaries, and from there, I think we will be able to deal with all the challenges without fighting. The department, like I said, we had our national Indaba in Bloemfontein somewhere in July, or was it June? The reason why we had the Indaba is the DG, after getting all the complaints for maintenance and the likes, Number one, he wants to improve the service, but mostly he wants to professionalize and create career pathing for maintenance officers, because that's where the challenge is. But I must share with the House that most of the time it's all about attitude, because maintenance, domestic violence, these are services that when you are appointed, you should know that there, despite the salary that I'm getting, is community service. So if you don't passion, you don't have passion, I don't see you definitely surviving in that area. So normally when you attend and you speak to stakeholders and you hear the first and the second speaker saying, this is what is happening when I go to the maintenance court. It's not like we are numb to the challenges. It's because we know that these challenges, they are there, and we need to find a way of ensuring that we definitely deal with them and we definitely improve services, because we are not there for ourselves, but we are there for the public. Thank you.
My apologies for the trouble in the beginning. It's nice to know that the department cares, that one can always work. The next speaker is Professor Clement Marumoagae. I think I saw him somewhere on the list. Clement, can you hear me?
Yes, I can certainly hear you.
Okay, great. I'm just going to quickly get your. Do you want to share the screen?
No, I will not be sure. I don't have slides, so I won't be
Okay,
sharing
excellent. So we can just listen to you. Fantastic. Your 20 minutes starts now. Thanks.
Thank you very much, Chair, and good afternoon to all the colleagues. I'm not sure. Good afternoon to all the colleagues. I'm going to talk to you about something that I'm currently working on, which is the intersection between family law and pension law in respect of maintenance. And a lot has been spoken about as to how you go about claiming maintenance and some of the challenges. I'm not going to deal with that, but I'm just going to deal with this aspect that has always been there, but it doesn't seem like it is being, in practice, being utilized to the extent to which it should be. So basically, in this paper, I just discussed the circumstances under which the duty to maintain children may be discharged through payments from retirement benefits. And I will try to demonstrate that while it is tried that payment of area maintenance can be paid from the defaulter's retirement benefits, the law is not entirely clear in relation to future maintenance. And I've listened to the previous speaker speaking about the difficulties that arise in respect of future maintenance. And to some extent, pension law does provide some answer, even though it's not that satisfactory. Now, in this paper, I will be evaluating whether it is justifiable to use retirement benefits when one understands why these things have been created, then to settle the defaulter's child maintenance obligations. And if this is justifiable, how then this should, how we should go about doing that as a nation. Now, perhaps maybe one has to start from the bottom with the concept of duty of support. Child maintenance is a common law duty entrusted on each parent in line with their relative means and circumstances and the needs of the child from time to time. And we all know that parents do not necessarily have to contribute equally. They just have to contribute in accordance with their respective means and depending on who has the child. Because sometimes there's this conception that the person who needs to maintain the child is the person who does not live with the child. But you find that the person who lives with the child may be spending even more because that person is aware of the daily needs of that child. So the one who is not residing with the child also must come into the arena and make sure at the end of the day he contributes proportionally in respect of their means and the needs of the child. This duty does not terminate when the child reaches a certain age, but it can also continue up until the child reaches is self-sufficient and is able to stand on their own feet. But when parents separate, one of them will usually be granted the care and residency of the child, and the other might be ordered to contribute towards the maintenance of the child. And when one looks at Section 15 of the Maintenance Act, it states that a maintenance order for the maintenance of the child is directed at the enforcement of the common law duty of the child's parents to support the child, as the duty in question exists at the time of the issue of the maintenance order and is expected to continue. So you see that not only is this a common law duty, but it's also a statutory duty, which parents must actually comply with. Now, there are different ways in which a person can claim maintenance. You don't necessarily have to go to court to claim maintenance. I mean, one of the ways will be to just call the person who needs to pay maintenance and say, look, we have a child here, and this child needs 1, 2, 3, 4, 5, and please, can you contribute towards where I cannot reach? And once the parties are in agreement, then there can be an agreement between themselves as to what will be payable on a month-to-month basis, or on a week-to-week basis, or on whatever term that they agree on, to make sure that the child of the life becomes easier and the child is maintained. Sometimes you might find that they are unable to reach that agreement because maybe the emotions might be high, they don't no longer see eye to eye, they're using the child as a tool between the two of them while the child is suffering. So under those circumstances, then there might be a need for one of them, or the one who has been awarded the care and the residency of the child, to approach either the maintenance court if maybe they are not married and they just want to make sure that maintenance comes to claim, or during divorce proceedings, as one of the can actually plead for maintenance, and as one of the prayers claim that the one who's not going to be residing with the child should actually pay a certain amount towards the child's maintenance. And we know that once a maintenance order has been granted, either by the maintenance court or the divorce court following the divorce proceedings, then usually the person who has been ordered to pay maintenance may default in his or her maintenance obligations. And by the way, it's not only men who can actually be taken to court to pay maintenance. I mean, in my practice, I see more and more men actually claiming maintenance from women to maintain their children. So it is a gender sort of neutral, even though we know in practice, in most instances, you'll find that it's women who usually will claim for maintenance. So it is gendered by its very nature, but we see trends where men also do claim for maintenance. Obviously, once one party has defaulted, then as it has been said throughout the day, then a person can apply for a warrant of execution, or there might be an issue with a garnishee order in terms of Section 28, or there might be an attachment of a debt in terms of Section 30, or there might be criminal proceedings, contempt of court proceedings, which can also be an effective way of trying to enforce a maintenance order. But let's assume that all those things that have been discussed throughout the day, they don't work. And it appears that, look, there is no way where maintenance obligations can actually be satisfied. Now, when you look at Section 26 of the Maintenance Act, among others, states that when a maintenance order has been granted and the person against whom it has been granted failed to make payment in accordance with the order, such an order is enforceable by execution against the defaulter's property. Now, that is one of the ways in which you can ensure that some maintenance or some money can be taken from those properties that can be sold. But if that doesn't work, or maybe the word property is defined quite broadly to include retirement benefits. In other words, Section 26, subsection 4 states that any person, annuity, or any pension, annuity or gratuity or compassionate allowance or other similar benefit shall be liable to be attached or subjected to execution under any warrant of execution or any order issued in order to satisfy a maintenance order. Now, the Maintenance Act itself, it does provide leeway to ensure that a person can attach retirement benefits for the purposes of ensuring that maintenance is paid. Now, when one looks at the wording of Section 26 of Section 4 of the Maintenance Act, it deals with area maintenance. In other words, there should be somebody who owes maintenance in order for that, for the person who is owed that money to be able to approach a court to say, look, I'm owed the money. I want this person's pension benefits to be attached in order for the obligation to satisfy the maintenance to be respected. So we see that already there is this provision in the Act where legislatively somebody can actually institute legal proceedings to ensure that retirement benefits are attached. But it becomes a little bit complicated like that, because when one looks at the entire framework of retirement law or pension law in South Africa, it's very much fragmented. There is no one legislation that regulates the entire retirement funding industry, if you like. You find that there is so many legislation that regulate certain parts of the pension industry, but most of the private retirement funds are regulated by the so-called Pension Funds Act 24 of 1956. So when you look at this particular act and others as well, they always have a provision that protects retirement benefits from being attached. Like for instance, in as far as the Pension Funds Act is concerned, it is section 37A of the Pension Funds Act and section 21 of the Government Employees Pension Law, Proclamation 21 of 1996, and the others as well, they have similar provisions, where in terms of those provisions, retirement funds cannot be attached, cannot be reduced, and they cannot be transferred. In other words, you find that that provision already seems to be in conflict with section 26, subsection 4 of the Maintenance Act. And now it becomes an issue as to which provision or which legislation should prevail when you compare the two, because the other one says, look, you can actually institute proceedings to claim area maintenance. The other one says you cannot attach this provision. But inherent in the Pension Funds Act and the other legislation as well, we have provisions. Section 37D of the Pension Funds Act, it allows certain deductions to be made. It calls them allowable deductions. And you find that in terms of this section, you can have a pension interest. In other words, when somebody is divorcing and they want to claim a portion of the other person's money, they can actually claim a portion through section 37D, which is an allowable sort of deduction. Also, it allows SALRC, for instance, to deduct what it is owed from somebody's pension benefit. That is also an allowable deduction. It also allows where the pension fund has a scheme where you have been granted a loan, a home loan. It allows the bank to be able to claim what is owed through that section 37D. But most importantly, for the current purposes, it also allows for the attachment of retirement benefits through or when there is a maintenance obligation that has not been satisfied. So in other words, maintenance of children, it is an allowable deduction in terms of the Pension Funds Act. So there is no conflict, as it were, between the Maintenance Act and the Pension Funds Act. The Pension Funds Act itself, it creates a mechanism which supports or complements section 26, subsection 4 of the Maintenance Act to allow the person who claimed the maintenance on behalf of the child to be able to go to court and claim maintenance on behalf of the child by attaching the member's pension benefits. Now, while it is clear that area maintenance can be claimed, what is not clear is whether future maintenance can be claimed on behalf of the child. And we have seen, and it is just concerning that most of these cases, they go to the magistrate court and you don't find a lot of reported judgment on this issue. But there have been selected cases that have dealt with this issue. We have a case, Mngadi versus Beacon Suites. It was reported in 2003. Solar versus Maintenance Magistrate, Berger versus Berger, Mageo versus Zozo. So all those cases, they grappled with these provisions as to whether a pension fund can allow a a party who claims maintenance on behalf of the child to be able to be given money to make sure that the maintenance obligation is actually satisfied. And what is interesting about these cases is that the earlier cases seems to be saying, look, you cannot claim, while you can claim area maintenance, you cannot claim future maintenance because a person is not yet in default. So you have to claim when the person is in default. And most of the cases were along those lines. But recently, we have seen a little bit of a change in attitude from the court. And in particular, before I go there, I mean, in Sentinel versus Retirement Fund versus Mtambo, the court was of the view that an order directing the retirement fund to pay an amount of future maintenance in one lump sum is contrary to the provisions of Section 37A and 37D of the Pension Funds Act. So initial courts were like, no, this cannot be done. You cannot claim, while you can claim area maintenance, you cannot claim future maintenance. Because how do you claim future maintenance? Because with area maintenance, it's like, okay, fine, there is this amount that is being owed. It's quantified already. We know what is owed, and this is what you can claim, and then you can go to court and say, look, I'm owed 500,000. This is what should be paid to me as area maintenance. But as
You
far
have
as
2
future
minutes
maintenance, how then do you determine it? How do you are you going to look at the past and say, look, the child has been or I've been spending this much on the child, and this is the amount that has been needed to support the child. So in future, this is the amount that will be needed. Can we do that scientifically? So the court was like, no, you cannot do that. You can only claim area maintenance. But we started seeing a change in attitude. I mean, the case of Macheu versus Zozo. It is a 2004 decision, volume 4, South African Law Reports, page 578. It was the Cape Division decision, Western Cape Division decision. In this case, in this judgment, in paragraph 24, the court held that the attachment of pension benefits in respect of future maintenance claims is a direct and effective means of ensuring that the rights of the child and the dignity of women are upheld. There is no reason why, in this instance, the pension fund should not be directed to withhold the withdrawal benefit in order to secure the future maintenance claims of the child. And of course, the court was basing this on the basis of Section 28, subsection 2 of the Constitution, the best interest of the child, and Section 7 of the Children's Act, which defines how you should go about with the best interest principle. So now we start seeing courts taking a different tune and saying, look, you can actually claim future maintenance. This kind of maintenance is not restricted to area maintenance. And of course, when one starts looking at some of these cases and how they were decided, even though there was no sort of a mechanism or did not provide the way in which one can go about to claim this future maintenance, at least they started providing a framework within which we can think about how this can actually be done and how we can effectively going forward to make sure that retirement funds can be approached, not only when there is somebody who has defaulted, but if somebody believes that somebody will default in future and say, look, I suspect that this person will default and I want to claim future maintenance because I want to make sure that the child is sorted out in future. Now, the purpose of this paper really is to investigate whether is or should the South African law or should the South African approach be that which allows retirement benefits generally to be attached for the purposes of paying maintenance claims. I mean, one has to look at why retirement benefits exist in the first place. These are financial vehicles which have been designed primarily to ensure that members of these particular funds are able to be self-sufficient when they reach retirement age. They were just tools to guard against poverty during old age. That was the intended purpose of retirement funds. But we have seen over the years, in the last 20 years or so, that the nature and the character of retirement funds changed, and their purpose has been widened. Like currently, retirement funds provide disability benefits, they provide funeral benefits, they provide other sort of benefits that really benefit. And you find that they invest also in different portfolios, and the way in which they are managed, you can see that their scope has been widened. Hence, we start thinking about how best then we can incorporate other things, like making sure that there are allowable deductions, which can ensure that whatever obligations that members of retirement funds have that are legislatively defined, they can actually be carried out. And of course, maintenance is one of them. And now it is clear that it is justifiable that if a member of a pension fund is unable to perform the duty that is legislatively entitled to perform, which is to care for the child, then you should be able to look to the retirement benefits and make sure that at the end of the day, these benefits are attached in order to satisfy those obligations. But I think it is important to look at this very carefully.
Clement, your time is
the
up.
case that I made, I beg your pardon?
I say your time is up. Please wrap up.
Oh yes, the case that I make in the paper is one. This should be retirement funds should be approached as a measure of last resort. It should not be something that somebody wakes up and just say, look, we know that this person is a member of a pension fund or a former member of a pension fund, and the benefits are still held by retirement funds. No, I'm going to attach these benefits. It should be something that is, you need to look elsewhere first. And once everything else has failed, then you can actually go into retirement funds. But most importantly, I think there should be legislative amendments that really makes that point. It should be made absolutely clear that, look, this is something that is not free for all. Because once you make it free for all, then it actually deviates from the intended purposes for which retirement funds were created. Okay, I will leave it there. But I think colleagues get a sense of what I'm trying to do with this paper. Thank you very much.
Thank you very much. I love listening to you in pension. You really are the expert in the area, and I know you always have something interesting to say and new and so on. And we're waiting for a few judgments, hopefully to come out soon, adding to the ones that we already have. So thank you very, very much.
Thank you very much.
Ladies and gentlemen, the next person is, just hold on a second. This Ilse, she's from the National Prosecuting Authority, and I can actually share my screen now again. Can you believe it? I don't know what happened earlier, but let's see. There we go. There we go. There's the screen. Your 20 minutes start now. There we go. You just tell me when.
Okay, that's fine. Thank you. Thank you to the Northwest University also for holding this colloquium. Excellent idea. I think it's about high time that all of these stakeholders in the maintenance or in the field of maintenance get together to identify and discuss challenges. So my presentation is sort of a concerted effort. I've invited my colleagues in the other provinces. I'm a senior maintenance prosecutor for the Northwest, so I've invited my colleagues, other colleagues in the provinces to share with me the challenges as well. So I've made a list of, all challenges that we came across with. Okay, just as an introduction, we all know that the Maintenance Act was and is intended to protect the most vulnerable members of society, mostly our women and children. The Act is a comprehensive piece of legislation designed to provide speedy and effective remedies at minimum costs for the enforcement of parents' obligations to maintain their children. Now, maintenance, we all know, is very often treated as a minor offense. It receives little or no prominence in the judicial system and has always been neglected to the backbenches of the justice system. Sometimes the most junior and the most inexperienced officials deal with these matters. Sometimes the maintenance office is a dumping site for those officials who do not perform. You get that quite often, unfortunately. So yes, that might also be one of the reasons people are defaulting and why we have such a high rate of arrears and defaults, because people who are placed who must take care of the maintenance in our courts do not have the necessary experience and expertise to deal with these matters. So I think, yeah, referring back to that, our culprits, our respondents, I don't want to say our men, they know that, and that's probably why they take chances as well. Now, complainants in the maintenance matters must often accept whatever paltry sum that is offered to them as maintenance. And maintenance orders are very often reduced at the very whisper that I cannot afford it. Okay, next slide. Okay. I came across a judgment, a recent judgment that I think 2 weeks back, where the magistrate, it was section 31 procedure in a trial, said maintenance is the most important part of the judiciary, because if we cannot afford our women and our children, our future generation, the protection they need, then we have lost a nation. We can ask ourselves, who are the criminals? Where do they come from? They probably grew up without money, without food, without clothing. Sometimes they got lured by crime. We created our own criminals because we could not afford our women and children the protection they needed. And I think it's quite true, no? A lot of it in it. To conclude, Nelson Mandela once said, our children are our greatest treasure. They are our future. Those who abuse them tear at the fabric of our society and weaken our nation. Okay, next slide. Now, a lot of the presenters refer to the Bannatyne matter. I'm also going to refer to the Bannatyne matter. I don't think I must actually read the whole, but it's quite important to do it, so I'll quickly run through it. Despite the Judge Mokgoro in the Bannatyne, the constitutional decision, said despite the good intentions of this comprehensive legal framework specifically created for the recovery of maintenance, there is evidence of logistical difficulties in the maintenance court that resulted in the system not functioning effectively. The complaints, what is it, the CGE again, my goodness, but in any case, gender equality, that's right, yes, placed material evidence before the court demonstrating the difficulties with the operation of the Act, including problems ranging from inadequately trained staff to insufficient facilities and resources. And I think as Eugene pointed out also, this case is a 2003, started in 2002 case, and it's still the same problem. We haven't moved from there. We have a beautiful piece of legislation, but we still experience on a daily basis these challenges. Systemic failures to enforce maintenance orders have a negative impact on the rule of law. The courts are there to ensure that the rights of all are protected. The judiciary must endeavor to secure for vulnerable children and disempowered women their small but life-sustaining legal entitlements. If court orders are habitually evaded and defied with relative impunity, the justice system is discredited, and the constitutional promise of human dignity and equality is seriously compromised for those most dependent on the law.
It is a function of the state not only to provide a good legal framework, but to put in place systems that will enable these frameworks to operate effectively. Our maintenance courts and the laws that they implement are important mechanisms to give effect to the rights of children protected by Section 28 of the Constitution. Failure to ensure the effective operation amounts to a failure to protect children against those who take advantage of the weakness of the system. Yeah, I think we can over and over read this judgment of the Bannatyne, and it's, like I say, it's still the same challenges. Okay, I'm going to start with a list of the challenges. It's not in order of preference. I've just jotted them down. We can start applicants not knowing their rights to maintenance, especially in the rural areas. A lot of public awarenesses needs to, public education, public awarenesses needs to be done to get this right. Women in the rural areas are traveling far, and transport to and from the court is extremely expensive. Women are turned away from maintenance courts who don't have the ID documents or birth certificates, while the DoJ Code 26 of 2015 states specifically no one should be turned away. That's why our public awarenesses and public education is so important, that we can inform the people what they need to bring, so that when they come to court, that they can be assisted immediately. Because in the rural areas specifically, yes, I don't know what taxi fees are these days, but we all know what the fuel price is. It's just increasing and increasing. And for a poor woman to come to court and pay 40, 50, 60 rand for taxi fees just to be turned away, come back, you know, it's money that she could have bought food for the kids, whatever. So we need to educate our people and see what we can do. You know, whenever they arrive at the maintenance court, they need to be assisted. Mothers staying out of work and compromising the employment while struggling with recalcitrant fathers to contribute to maintenance. Some courts only doing new applications on certain days and complaints on different days means mothers have to stay out of work more than once to access maintenance courts, or have to turn back and again spend some transport money to be ultimately assisted. Can refer again to the code, Department of Justice 26. No assistance from maintenance clerks, while Department of Justice Code states clerks should assist maintenance applicants to complete the J101 or J107 maintenance application forms. We have a lot of illiterate women approaching our courts for assistance. So clerks must be trained to assist them in completing the necessary forms. Now, a big problem is clerks are rotated frequently, which causes problems because it is right that maintenance is not only a specialized but sensitive section, and Department of Justice should prioritize staff retention and training before rotation. Okay, then the responsibility of maintenance prosecutors versus maintenance officers. Now, we've heard that the recommendation by the Law Commission is that the status quo must remain. I was one of those wanting the NPA to take up the responsibility to start on them by the Maintenance Act, because if you look at the Act, and I actually want to do it quickly, if you look at the wording of the Act, I just want to get the Maintenance Act here. It says specifically, and listen carefully, no? Any public prosecutor to whom a director of public prosecutions, that's section 4.1, has delegated the general power to institute and conduct prosecutions in criminal proceedings in a particular magistrate's court shall shall be deemed to have been appointed as a maintenance officer of that corresponding court. Okay, in the first instance. So every prosecutor is a maintenance officer, shall be deemed to have been appointed. Then the next one, the National Director of Public Prosecution shall, in consultation with the Minister, issue policy directions with a view to establishing uniform norms and standards to be observed by public prosecutors in the performance of their functions as maintenance officers. That is done. But shall, okay, doesn't have a choice. And shall build a more dedicated and experienced pool of trained and specialized maintenance officers. Okay. Then we come to section 4.2. The minister may, not shall, may appoint maintenance officers to appear in the maintenance court. So you can see where, I don't know if you guys agree, but where does the responsibility of maintenance lie? It's clearly with the National Prosecuting Authority. If you look at the wording of the Act, it's clearly, and I think, you know, I'm a prosecutor, but it is high time, and we've started this in 2000. We were appointed in 2000 as senior maintenance prosecutors, and we had maintenance prosecutors appointed by then. So we've started with this, but then, as Judge Tulare indicated, you know, with the Director of Public Prosecutions, the national directors, you know, it changed. So those maintenance prosecutors sort of died a certain death. But in any case, but we still train our prosecutors on a constant basis to attend to maintenance matters. But you can see where the responsibility lies. It's on the prosecution authority, not necessarily on the Department of Justice. Now, like Motshabi indicated, fortunately, you know, we have an excellent working relationship with the Department of Justice in the province. We work very well together. So if there is any problem, you know, we iron that out with regards to prosecutors, and we have a circular issued by the Director of Public Prosecutions for Northwest in place, who emphasized the importance of Section 4.1 of the Maintenance Act. So we do have our prosecutors in place to act as maintenance officers in Northwest Province. Surely we do have, you know, still incidents where prosecutors fail to adhere to this duty. But in general, we have it in place in our province, and hopefully we will soon have it in place nationally as well. Because like I say, it's really high time that the prosecuting authority take up this responsibility. Okay, next slide. Oh, no, it's not next slide. The supervision of the maintenance officers, court manager versus the senior prosecutor, but Prof Leentjie said it's also been addressed in paper 157. Then obviously staff shortages. Not one single province have a maintenance officer per court. Okay, so quite important, but yeah, prosecutors are there to assist. Unfortunately, at the moment, you know, we also have through government, but specifically in the NPA as well, austerity measures in place. So vacant positions are not filled. So we have to work hand in hand with the Department of Justice and see how we can assist. You know, whenever there is a vacant post as a prosecutor, we need the assistance of the Department of Justice to see if they can maybe make the services of a maintenance officer from a neighbor court available to assist in the maintenance in that specific court. Public prosecutors don't see themselves as maintenance officers despite Section 4.1 of the Act. That's true. We still have a lot of, you know, awareness, sensitization to do within the NPA, and we are doing that. We are our senior maintenance prosecutors, the SOCA unit, specifically sexual offences and community affairs unit, do our utmost best to nationally lift the maintenance division up within the NPA. We have our case law, Anna Mutamunye case, where the prosecutor neglected to assist the mother, complaining that the respondent will splurge his pension benefits. The court found the prosecutor grossly negligent in not helping the mother. So this also need to carry the message out and train prosecutors on specifically this judgment as well. Then we have our NPA policy, part 26, provide prosecutors become maintenance officers in the absence of the Department of Justice maintenance officer, which I'm not so happy with because it's not really the absence of a maintenance officer, they are maintenance officers. Then the non-availability of maintenance officers makes mothers depressed and lose faith in the justice system and rather give up on applying for maintenance. That's why I'm so interested in what's the name now? In the Felicity, what you said about that. I don't know if it's going to be a webinar or whatever, you know, that we need to attend specifically on reasons why mothers give up. That would be very interesting to hear what they are saying. And then, okay, obviously maintenance investigators, shortages of vehicles to conduct investigations and so forth. We also do not have a maintenance investigator at each and every maintenance court, so that is also problematic to us, because then we have to run around and look for a maintenance investigator in a neighbor court to do the investigations. Maintenance clerks or maintenance investigators at some courts have to occupy or fulfill the role of the maintenance officer, which is obviously you know, not supposed to be so, because they do not have the right of appearance to appear in the court. Okay, okay, let me quickly run through these slides. We know Department of Justice maintenance officer is at court and no prosecutor is available. The clerks do the work. Again, it's a no-no because they don't have the right of appearance, they don't have the expertise, they don't have the legal knowledge. Let's go to the next slide rather. Yes, I quickly want to touch on this one. Section 6, maintenance inquiries. I don't know why, you know, people, if they don't, are they not yet trained on this? You know, I hear Motshabi, you said that they do interim orders, but it's hard to find the interim orders, to be honest with you. We really need to train again our maintenance officers, you know, to ask for an interim order, because that's immediate relief. It's only where paternity is in dispute that the court cannot grant an interim order. Quickly run through this. Okay, and then obviously section 10(6)(a) as well. A maintenance court shall conclude maintenance inquiries as speedily as possible and shall ensure that postponements are limited in number and in duration. So we have the Act, we have these sections. We just have to apply it. We have to train our people to do it. The next slide. Okay, I'm going to skip this one also. The next one, I just want to get to the magistrates not being available for Section 10 inquiries. We actually need dedicated magistrates at our maintenance courts. I think it was in 2000 where there was the Cornerstone Commission. I don't know if you guys can remember that, where they've proposed the maintenance investigators and then family courts as well. That would have worked excellent, you know. But yeah, unfortunately, money is a problem. Okay, I think I'm just going to run to solutions. It's the last slide. I'll skip those slides. I'm sure the presentations will be distributed amongst all of us now. Okay. I've just dotted down a couple of solutions. Obviously, paper 157, Law Commission, the proposals, the sensitization of staff working in the maintenance section. We need to sensitize our people, train our people. Public education and awareness campaigns, community dialogue. One of these examples is in the Western Cape with my colleague Dion Reiters. They've got a community dialogue which works excellently. In the Western Cape, I think it's once a month that they, on a Saturday, that they invite the public to be part of it and address issues and so forth. And then collaboration with the Department of Justice in respect of training for maintenance officials. And I think multidisciplinary training is also quite necessary within the maintenance system. That will include then magistrates, clerks, maintenance officers, maintenance investigators, all in one training session so that, issues can be ironed out. Maintenance webinars, we've started with that in the NPA. Awareness through social media, we've started with that as well. And then I believe in our national and provincial maintenance forums to revive that again. National and provincial maintenance task teams, to have a task team in place, I think it's also an excellent idea. That can say, for instance, there's a specific court, that do have, or is not running smoothly and problematic things that we can attend to that. Provincial maintenance training team for in-house training, not just training, in-house training. And then Department of Justice training and NPA training on maintenance, we do that as well. But thank you for the opportunity.
Thank you. And I think maybe the university and you need to get together at some stage to see how we can help. Okay, ladies and gentlemen, our last presentation. Laurie, you're welcome. I will put yours up now. Yeah.
Just maximize. Thank you so much. For those of you, thank you, Prof Marita. For those of you who don't know me, my name is Laurie Gravenstein, and doesn't scroll down with the mice. There you go. Oh, okay. My name is Laurie Gravenstein. I'm an accredited mediator. I'm also involved with the Social Justice Foundation, and I'm the chairperson of NAPFAM, the National Accreditation Board of Family Mediators. I have 25 years of experience in formal dispute resolution and 17 years in informal dispute resolution. I've worked with maintenance cases since 1987, first as a maintenance officer, then a public prosecutor, a magistrate, and now since 2006 as a family mediator. Qualifications, I'm busy with my LLB on the topic that I'm presenting on today, so I'm going to share some interesting facts and news with you. The outcome of the research is a work in progress, and the relevant stakeholders have already bought into my proposal. It offers achievable solutions to a pressing socio-economic problem. My supervisor is Professor Leentjie de Jong. Thank you. And continue. Just on the content, outline of the thesis, I deal with the duty of support. Secondly, the traditional method of resolving maintenance disputes, then on to alternative dispute resolution options to resolve maintenance disputes, the need for a centralized maintenance register, and lastly, the establishment of a dedicated credit bureau to serve as a centralized maintenance register. The introduction: in an ideal world, children would grow up with both biological parents in one home. The divorce and unemployment rates would be low. Few children would be born out of wedlock. The state would be wealthy. Orphan children would be cared for by the state, and divorced and unwed parents would willingly take care of their children's financial needs until they are fully self-supporting. But the reality is that we do not live in an ideal world. Divorce and family breakup are often complicated by emotional effects, and although parents may love their children, they are frequently struggling with unresolved issues that hinder them from thinking clearly and being open about their finances. Maintenance disputes frequently arise. Some disputes are settled amicably, but many end up in court. Carnelley correctly states that there is a culture of non-payment of maintenance in South Africa. Parts of the current maintenance system have become so obsolete that it no longer serves the best interest of children and other vulnerable people who are legally entitled to financial support. Next one, please. A multidisciplinary approach is necessary if we are to create new insights into the pressing societal demands and social economic needs that are evident in maintenance cases. Fresh insights are needed to improve law reform processes on various levels, thereby contributing to the development of new legislation and influencing approaches to the centralization and integration of the private maintenance system with other public and private sector systems, as well as to the extension of credit and the keeping of records of persons with maintenance obligations. The proposed approach is technologically advanced, reduces the discretionary powers of court officials, and can fit into the well-established and regulated credit bureau environment. A sophisticated system can significantly reduce human intervention, thereby reducing costs, time, and preserving relationships. This research campaigns for the establishment of a national central maintenance register that will record all maintenance orders and keep a record of persons who do not honor their maintenance obligations. The register should function as a dedicated maintenance credit bureau for maintenance orders only and interact with the financial sector and the credit industry. When credit consumers apply for credit, the credit providers will have access to such consumers' maintenance obligations. Credit consumers who evade or conceal their financial responsibilities to their family will be prevented from obtaining further credit until their maintenance obligations have been paid in full. The national credit regulations provide for the consideration of maintenance obligations when someone applies for credit, but there is no easy point of access to such information. Although the Maintenance Amendment Act provides for the information on maintenance defaulters to be handed over to credit providers and credit bureaus, this information is not readily accessible. Credit bureaus are positioned to process data of a financial and private nature from various public and private sector platforms where such data is crucial in dealing with maintenance cases. The Central Maintenance Register should encourage alternative dispute resolution before escalating cases to litigation. A Central Maintenance Register offering online services could provide access to justice by first funneling cases through online dispute resolution, and when disputants cannot settle through online dispute resolution, referring them to suitable alternative dispute resolution mechanisms, such as private or community-based mediation. Only when ADR is unsuccessful should disputants be referred to litigation as a last resort. This would encourage biological parents to take care of their children's financial needs, enhance the role of courts by reducing their administrative functions, and encourage disputing parties to settle disputes amicably. A maintenance inquiry is first and foremost a financial inquiry. Many disputed maintenance cases that end up in court are argued based on the availability of financial resources. Dealing with the problem, it is acknowledged that the maintenance system needs rigorous changes if it is to be effective. This study does not, however, focus on previously identified problems within the maintenance system. A major problem identified by existing research relates to the lack of capacity and infrastructure of the maintenance court system to deal with the workload, which is created in part by insufficient maintenance legislation. This study focuses on a system that emphasizes the responsibility of non-residential parents to provide for their dependent children and on methods of dealing with maintenance defaulters, the reporting of all maintenance orders and defaulters to credit bureaus, and the handling of disputes pertaining to maintenance matters. Private maintenance orders are granted in different courts. Unfortunately, there is no clear indication of the number of maintenance orders in operation in South Africa. More than 60% of registered births in South Africa in 2021 reflected no information on the biological fathers on the birth certificates. Courts receive more than 200,000 new applications for maintenance annually, but these figures fall far short of the need for maintenance orders. A mere 34% of children live with both biological parents, and 42% live with their mothers but not their fathers. Only 4% of children live with their fathers but not their mothers. South Africa's total population is estimated at 60 million people, of whom 20 million are children under 18 years. Children make up 34% of the total population. The 66% of children in need of maintenance represent 13.2 million children. The divorces and 200,000 maintenance cases finalized in court annually are a drop in the ocean in relation to the actual need. There were 1,265,753 live births in South Africa in 2022, while the need is for 835,397 new maintenance orders per year. On new births alone, there is a deficit of 1,065,753 maintenance orders annually, excluding the existing need for the servicing and substitution of current orders for 13.2 million children. In fact, if 13.2 million maintenance orders are reviewed biannually, then on average, every magisterial district must review 74 cases every single working day. Now, just on this point, only the Pretoria court deals with something like 74 cases per day. If they finalize between 2 and 4 cases per day, they're having a great day. The maintenance court system does not have the capacity to deal with the sheer volume of cases, and drastic alternative measures are necessary to address the need. The vital need for an efficient maintenance system is emphasized by the alarming statistics on the numbers who are dependent on the state for survival. 29 million people in South Africa receive monthly grants. 18 million South Africans receive state welfare grants, with another 11 million relying on the state's 350 Rand grant. South Africa only has 7.4 million individuals with taxable incomes, a quarter of the number of people who receive grants. 50% of the credit active consumers are over-indebted. Over-indebtedness is a common excuse by respondents during maintenance inquiries in court. Maintenance obligations are considered as part of a person's credit profile, which must be considered when they apply for credit. But 8 years after the amendment of the National Credit Regulations, there is still no system that provides for the implementation of this amendment. Maintenance defaulters can be listed with credit bureaus, but there is no dedicated credit bureau processing maintenance orders. I've personally lobbied for this for many, many years. And then it was amended 8 years ago, but still nothing happened. If there were a dedicated credit bureau, credit providers would be denied an opportunity to provide further lending, and persons with maintenance obligations would be able to provide for their dependents. Government must fix this problem. Ilse also mentioned the Bannatyne case. The Constitutional Court found, while the obligation to ensure that all children are properly cared for is an obligation that the Constitution imposes in the first instance on their parents, there is an obligation on the state to create the necessary environment for parents to do so. Moving on to the duty of support, briefly, Section 28(1) of the Constitution grants every child the right to family care or parental care or to appropriate alternative care. Although this duty focuses on private maintenance, on the private maintenance system, it includes an evaluation of both private and state maintenance systems. Primarily, parents must take financial responsibility for their children, and the study investigates various possible ways of achieving this requirement. It is in the best interest of children to gather as much information as possible to be cared for. Onto the traditional method of resolving maintenance disputes. This study analyzes the provisions of the Maintenance Act, identifies limitations, and makes suggestions. The South African Law Reform Commission is investigating, in addition to the recovery of maintenance for children, the reform of the entire South African maintenance system. The formal approach through the maintenance court system is based on an argumentative and litigious approach by family members who are not necessarily in disagreement. Parents are formally drawn into litigation proceedings against one another. They must attend court, prepare their cases, and produce evidence. The process is not conducive to the preservation of relationships, and it does not promote the principle of the best interest of children. 3, the need for a centralized maintenance register. The study investigates the use of a centralized maintenance system with a strong internet presence to process the relevant data and documents of all parties with maintenance files electronically at a central location. The central maintenance register will serve as a conduit that receives and feeds information between all relevant stakeholders, including the dedicated maintenance credit bureau, the courts, and maintenance clients. The processing of personal information of maintenance clients and minor children may be foreseen as a weakness or concern for the Department of Justice, which hosts the information in maintenance matters, but this is the motivation for having a dedicated credit bureau. The department can share the information conditionally with a single niche credit bureau that specializes in maintenance orders only, instead of sharing the information with the registered 52 credit bureaus. The financial sector and credit industry have already taken precautions in their codes of conduct to align the processing of personal information with the provision of Section 39 and the requirement for complaints, checklists, and guidelines of the Office of the Information Regulator. Alternative dispute resolution options to resolve maintenance disputes. The study introduces ADR mechanisms as possible informal options available to find solutions for dealing with maintenance disputes. The Family Dispute Resolution Bill of 2020 under Project 100D provides for mandatory mediation for all family disputes, and it makes provision for certified mediators. Different alternative dispute resolution options are analyzed, including dialogue, conciliation, collaborative law, private and statutory mediation, arbitration, and parenting coordination. Mediation has evolved over time and has become the main alternative for resolving family disputes out of court. In the event of settlement, the agreement of the parties can be made in order of court. The use of forms of ADR and online dispute resolution is entrenched in resolving credit bureau disputes, and existing processes can be adapted and integrated into a centralized maintenance system. Artificial intelligence and algorithms are synonymous with ODR in credit bureaus and other disputes and offer opportunities for resolving maintenance disputes. Family mediators already utilize program calculators successfully during maintenance mediations. Artificial intelligence and mediation have become increasingly intertwined. By combining the two, users can benefit from the advantages of both and achieve more effective outcomes. The use of an internet-based centralized maintenance system has the potential to give marginalized persons and communities access to justice, which many South Africans are currently deprived of. Online dispute resolution is a web-based system in which minor differences can be resolved by the proverbial press of a button, and more complicated disputes can be funneled to other appropriate dispute resolution mechanisms, either online or face-to-face. In the credit bureau industry, automated decision-making and information matching programs are already in use. The establishment of a dedicated credit bureau to serve as a centralized maintenance register. The point of departure for this study is the establishment of a dedicated credit bureau. Although international instruments support the concept for arrears maintenance to be listed on credit bureaus, it is argued that the One more. There you go. It is argued that the concept should be extended to all maintenance orders. An analysis of the financial services sector is provided before focusing on the role and function of credit bureaus, the credit industry, credit granting, credit rating, and reckless credit. SALRC draws all qualifying companies in the credit industry together to share information on their clients' payment and risk profiles with the credit bureaus. It safeguards that identical data is shared among all SALRC's members. The dedicated credit bureau would become a member of SALRC. The national credit regulator plays an important role in the formal credit industry, regulating 8 ADR agents, 52 credit bureaus, 6,675 credit providers, 1,699 debt counselors, and 4 payment distribution agents. Credit bureaus play a vital role in the credit industry and the South African economy. Credit providers must consult credit bureau records to ascertain consumers' monthly obligations to establish affordability, taking any decision to grant credit. Dispute resolution systems utilized in the credit industry are well developed and a dedicated credit bureau for maintenance disputes could benefit from existing systems that are mainly processed online. Many South Africans have access to smartphones and the internet. Statistics indicate that there are 26.3 million smartphone users, 41.19 million active internet users, and 28 million social media users in South Africa. The World Economic Forum suggests that governments change their current approach to public engagement and policy making to rely on sources which are made possible by new technologies. In conclusion, the Maintenance Act has not kept pace with the modern world. Access to justice in maintenance cases can be achieved and delivered by using technology. The credit industry has a responsibility to limit over-indebtedness and to stop extending reckless credit. Maintenance defaulters will be minimized and prevented from hiding assets and finances. The implementation of the proposed system shall, 1, bring speedy relief to many vulnerable women and children. 2, give government control over a problem that is out of hand. 3, bring irresponsible parents to book. 4, hold the credit industry accountable to limit the extension of credit to qualifying applicants only. 5, offer practical solutions to a massive socio-economic problem. 6, create job opportunities for ADR practitioners. 7, change social behavior for the better. And 8, create a culture of parental responsibility. The Constitutional Court found in the Grootboom case that it is the function of the state not only to provide a good legal framework, but to put in place systems that will enable these frameworks to operate effectively. Then just onto the last slide. As some of you have already seen yesterday, Anneke presented on the co-parent app. Now, this is an example of the initiatives on online dispute resolution, which was initiated by Social Justice. It is already available on all major app stores. It allows participants an opportunity to submit maintenance orders to credit bureaus. And there are some other online dispute resolution initiatives that's on the way soon. For instance, to help members of the public to recover arrear maintenance in an easy way, and also to connect them with credit bureaus once again. I thank you.
Thank you very much. What a wonderful positive note to end a new ideas how to get through these